It is my distinct honor to welcome you all to the Ethics and Risk Management in Behavioral Health training. I hope you are all as excited as I am to be here today and learn from the absolutely amazing Frederic Reamer and Robert Landau, two of the top ethics experts when it comes to mental health and the law. It's going to be a great day. Before we begin today's training, I would like to go over a couple quick things because I know there always are some questions. If you have any general questions regarding CE or the event, please visit the FAQ page in your event portal that you use to access and launch this webinar. As well, if for any reason you cannot hear either of the speakers as clearly as you would want, closed captioning will be available for the entirety of today. This can also be found in the Zoom toolbar if you'd like to turn it on. Shout out as well to our ASL interpreters that will be on the call. Always great to see. If you have any content-related questions that you would like answered, there will be a Q&A feature that will be available in the Zoom toolbar. That will open up in about 30 minutes and then will be available for the rest of the day. If you see questions you like or would like specifically asked, please click the thumbs up underneath those questions. That way, that allows us and the speakers to prioritize those and try and get to the ones that most of you want to see answered. I got to give a credit to our amazing speakers today. They have agreed to go above and beyond in answering questions, and actually will be taking turns answering questions within the actual physical Q&A button. So keep track of your question as it might get answered by them while they're actually teaching. Today's breaks currently scheduled to be mid-morning, so 10:45 Central Time. Lunch will be at 12:50 Central Time. That will go to 2 p.m. Central Time. Mid-afternoon break will be at 3:30 p.m. Central Time. We will keep these in the chat as well to keep you guys on top of that. A couple reminders around CE credit. If you have purchased live CE credit, your live CE certificate will be made available to you at the end of today's training. If you have not purchased CE credit, there is still time to do so. All registrants will have 14 days access to the recording from this once it goes live. If you would like to have unlimited access to that recording, that is an option via the self-study upgrade option in your portal. I want to give one last heads up as well. The handouts are available in the portal, but they are combined into one. That means that some of the page order might not match up with what the presenters are actually presenting. We do apologize for that inconvenience. Without further ado, because I know I talk way too much at the start of these, I would like to hand it over to our absolutely amazing presenters today.
Thank you, Spencer. And no, you didn't talk too long. That was just great. That was great. Thank you, Spencer, who comes to us from PESI, that's sponsoring this webinar. And welcome to all of you. As Spencer said, good morning or good afternoon or good evening. We know from experience that on occasion, we do get folks who are joining us from Europe or Asian countries, and some of them are pulling all-nighters to listen to this sort of thing. Whatever time zone you're in, and I imagine some of you are starting very early in the day, welcome, welcome, welcome. So I'm Frederic Reamer. I go by Rick. I'm joined by Robert, also known as Bob Landau. We'll spend just a few minutes introducing ourselves, and then we'll let you know what we're going to do today, and then we're going to dive into this material. Nearly all of you are clinicians, so let me acknowledge the elephant in the room. I imagine all of you are familiar with that phrase. When there's an elephant in the room, like in a therapeutic session, acknowledge it. We know this is a very long day, number one. We're doing this remotely, so it might seem a little less engaging than if we were doing this face-to-face. We're going to do our very best to keep you engaged throughout the day. Number two, the elephant in the room. We're going to be talking about ethical issues and risk management issues for the entire day. And let's face it, most people don't get up in the morning, look at their schedule, see that they're going to spend the entire day talking about ethics and risk management, pump their fist in the air. I can't wait. Life doesn't get more exciting than this. Well, we're going to try to keep it exciting. And this is going to be very, very practical. What's really unusual about this presentation is that you're getting the combined views of someone who specializes in professional ethics, that's me, and a lawyer whose entire practice, and he'll tell you more about himself in just a few minutes, his entire practice focuses on defending, he doesn't sue anybody, defending health and behavioral health practitioners who are struggling with risk management issues, some of whom have been named in licensing board complaints, and in lawsuits, unfortunately. But he also spends an awful lot of his time helping people prevent those problems. So you're getting the combined view of an ethicist and a lawyer, and that's unusual. So I have been on the faculty in the Graduate School of Social Work at Rhode Island College in Providence, Rhode Island since 1983. Do the arithmetic, that's 40 years. I became a social worker decades ago, not to focus on the issues we're addressing today, rather to work in prisons. That's always been my passion outside of my academic work. And I've spent actually 27 years of my career working in federal and state prisons. Many years ago, when I was working with a federal inmate in Illinois, I encountered my first very significant ethical challenge when that inmate shared with me information that led me to believe that he posed a threat to another inmate who I thought he might assault, which does happen in prisons at times. And I had to make a difficult decision about whether to keep that information confidential, whether to disclose it without his consent to prevent harm. You're all familiar with that concept. Interestingly, that happened 1 year after the famous Tarasoff decision was handed down by the California Supreme Court. We're going to talk about some of those issues later, including the fact that despite common perception, Tarasoff is not the law of the land, but more about that later. And I have spent decades now serving as an ethics consultant, an expert witness, to use the lawyer term, the court term, in litigation and licensing board cases, where very, very often I have to provide sometimes behind the scenes consultation on ethics and risk management cases, sometimes testify in depositions, sometimes testify at trial, sometimes testify at licensing board hearings. I was privileged to have chaired the national task force that wrote the code of ethics for the social work profession. I imagine quite a few of you are social workers, so I spent almost 2 years of my life helping to draft the code of ethics that applies to many of you here today. And I've spent much of my research career focusing on the issues we're talking about today. Bob, why don't you tell people a little bit about yourself? I know you're going to do more of that later, but give them a little brief intro, please.
Thank you, Rick. Good morning, everybody. I'm Bob Landau. I'm in Providence, Rhode Island. I'm an attorney, as Rick mentioned. I'm admitted to practice in Rhode Island and Massachusetts. I actually also started my practice in 1983, and I'm at the same law firm I began at right out of law school, which is pretty rare these days. My practice does focus on representing healthcare providers, defending them in malpractice lawsuits and licensing board complaints, and providing risk management consultation. Although I'm not able to give legal advice and particularly to opine, as we say, as to laws in other jurisdictions, I think you'll find that through my decades of experience, the process that I describe, the general guidance that I give, will be very useful to you, even though it won't address specific laws in your states. And of course, as to federal laws, that applies to everyone equally, which I'll also be addressing through the course of the day. So I look forward to speaking with you at different times. Rick will go first. After a break, I will begin my presentation, and then we'll have lunch. I'll continue a bit, and then Rick will close the sandwich. So it's a long day, but I hope to keep it engaging, and good luck. Enjoy the day.
Thanks, Bob. So just a few other logistical things before we dive into the material. And we also want to find out something about you folks. We're not going to go around the room and have you introduce yourselves. We would be here until like February if we went around the room here. We have nearly 1,000 people with us today. But we do have some poll questions for you because we want to tailor this presentation as much as we can. So in just a bit, I'm going to post some poll questions so we can find out a little bit more about your backgrounds, but also with respect to your knowledge of some of the issues we're going to talk about today. For those of you who came in perhaps a few minutes late, there are 2 PowerPoints. I developed one, Bob developed one. They are combined in one very long PDF. So the slide numbers on the screen when we pull our PowerPoints up may not correspond to the page number on your PDF. We'll do our best to keep you oriented there. Here's a caveat. Our PowerPoints are long. There are lots of slides. Bob wins the award. His is much longer than mine. We have put quite a bit of time into developing these PowerPoints. We will not be able to get to all the slides, not even close. So much of the material in the PowerPoints is supplemental resource material that you may want to take a look at if you are interested in any of these issues when we're done today. But please know, we cannot cover all that material. It's just impossible. It's a resource we hope you'll take advantage of. Another logistical thing, I assume by now you're all familiar with the distinction between a Zoom webinar and a Zoom meeting. During the past 3.5 years, since COVID fell out of the sky, we've all learned a lot about these things. This is a Zoom webinar, meaning we can't see you, we can't unmute you, you won't be able to ask any questions coming out of your mouth, but you can use the Q&A at the bottom of the screen. Okay, Zoom webinar, not a Zoom meeting. We don't get the Hollywood Squares thing with all the participants there. Today, we are going to be talking about lots of ethics standards, and we're going to be talking about lots of laws. As Bob mentioned, both federal and state laws. We're going to be focusing on federal laws that apply to all of you, or at least many of you. However, if any of you are providing behavioral health services in the military, and it's not unusual for us to have behavioral health professionals who work for one of the military branches, there are some unique federal laws that you need to know that we're not going to be spending a lot of time on today. For example, Military Rule of Evidence 513, that's literally the number, that addresses so-called psychotherapist client privilege in the military. And the rules are very different if you are a psychologist, psychiatrist, mental health counselor, social worker, marriage and family therapist in the military. We're not going to be spending a lot of time on that today because it doesn't apply to most of you. Some of you may be providing behavioral health services for the Veterans Administration, Veterans Affairs. There are some unique laws governing behavioral health at the VA that don't apply to people who don't work at the VA. We're not going to be spending a lot of time on those today. Okay, a couple of other quick things. We sometimes have participants ask us questions like this. Oh, you just mentioned that we should be using encrypted text messaging and email software. We should not be using our text messaging software that we get from Verizon, AT&T, T-Mobile, et cetera. And we are going to say that because you're communicating PHI, protected health information. People sometimes ask, oh, which software do you recommend? We cannot recommend any products. We can't endorse any products. We hope you understand that. We can talk about how to find them, but we can't endorse particular products. We can't endorse particular malpractice insurers. We're going to be talking about malpractice insurance. Bob especially is going to do that. We cannot recommend particular insurers. We encourage you to ask around, check with your colleagues if you need recommendations. I predict that some of you are going to conclude by the end of the morning that you need different insurance than you currently have. Or some of you are going to need to get it for the first time. Bob will talk about that. And for those of you who came in just a bit late, we do plan to take a 15-minute break mid-morning. Bob and I are on the East Coast. That'll be 11:45 our time, 10:45 Central. That'll be 8:45 on the West Coast. You can make the adjustments depending upon the time zone that you're in. We're breaking for lunch, 1:50 East Coast, 12:50 Central. Again, make the adjustments depending upon your time zone. And we aim to take an afternoon break for 15 minutes at 4:30-ish Eastern time, 3:30 Central, and that'll be 1:30 on the West Coast. Okay. Bob, did I miss any logistical details before we find out more about who's here?
I think you're all set.
Okie dokie. So, as advertised, we do want to spend just a little bit of time here finding out something about you folks, so that we can tailor our material as much as possible. Okay, so let's go to the first one. On the screen, you should see a list of the usual health, behavioral health professions. By the way, you may have to scroll down on the right-hand side, the little gray vertical bar. You have to scroll down to see all the options, but please tell us whether you're a social worker, a marriage and family therapist, mental health counselor, psychiatrist, et cetera, et cetera, et cetera. We recognize, by the way, that some of you may have more than one professional license. You may be a mental health counselor and a substance use disorder specialist, but pick the one that's, primary, so to speak. And we'll take just a moment for you folks to complete this. You should know we have over 1,000 people with us today, and it's going to take just a little bit for all the data to get loaded, although it's coming up pretty quickly. Thank you for your patience. We'll wait just another minute or so. We also recognize that some of you may be sitting in small groups, in which case only one of you can answer the question online. We're almost there. All right. In the interest of time, I'm just going to stop this and share the results, and you can get a sense of who's here with you today. We have 298 social workers. We have 43 substance use disorder professionals. We've got 95 marriage and family therapists, 355 mental health counselors. We have a number of nurses. I'm guessing psychiatric nurses. We have several psychiatrists. We've got 147 psychologists. We have 55 air quotes other. So don't know exactly what that includes. Perhaps some of you are educators primarily. I just do want to point out that we do have a number of substance use disorder specialists today, and we are going to talk a little bit about a particular federal regulation that is especially relevant to you folks. You may know of it. It's known as Title 42, Code of Federal Regulations, Part 2, Title 42, Code of Federal Regulations, Part 2. It's a very long, complicated document. If you are having trouble sleeping at night, any insomnia, we recommend that you read Title 42, CFR Part 2, because it could help you fall asleep. It is also really important to know Title 42, CFR Part 2 if you are a substance use disorder treatment professional who falls under 42 CFR Part 2, because the guidelines are much, much, much stricter than HIPAA. HIPAA may apply to you, but if both apply to you, 42 CFR Part 2 is much stricter. And Bob and I have both encountered cases where practitioners were confused about this and didn't know what they needed to know. So please pay attention to that. Okay. So that gives you a good sense of who's here. Let's go now to the next question. Oops, let me go to. All right. I recognize some of you may work in more than one setting, but which setting do you work in primarily? We recognize some of you may have a part-time job in addition to a full-time job. Again, you may have to scroll down on the right-hand side, that little gray vertical bar to see all the options. Outpatient mental health center, private practice. So we're distinguishing between working in a mental health center and private practice. Outpatient substance use disorder treatment setting, residential mental health treatment, psych hospital, and so forth, group home, residential substance use disorder treatment. Some of you are working in criminal justice settings. We couldn't list all of them out, and we recognize that may include institutional settings, prisons, probation, parole, all that. I can see already we have quite a few people working in school settings as school counselors, school social workers, quite a few of you in hospital and healthcare facilities, perhaps a nursing home or a rehab facility. And then other, we have quite a few others. Again, maybe you're educators, maybe you're working for the insurance industry, I wish we could go around the room and find out. Unfortunately, we can't do that. So again, bear with me while we wait for more people to respond. We've got nearly 900 people who've already responded. Thanks for your patience. We'll wait just another moment. This feels like election night when you're waiting for the, all the vote totals to come in. They're still coming in. All right, I'm going to stop it there just in the interest of time. So you can see that we have quite a few people working in outpatient mental health centers, and many of you, a little under half of you, are in private practice. We have a number of people working in outpatient substance use disorder treatment programs. Again, 42 CFR Part 2 might be particularly relevant there. A number of you in residential mental health treatment settings, residential substance use disorder treatment settings, 42 CFR Part 2, also very relevant there. A number of you in criminal justice settings, which is, again, my background as well, and quite a few of you in school settings. So as an example of what we're going to do, we're going to also talk a little bit about Title 34, Code of Federal Regulations, Part 99. That rolls right off the tongue, huh? Also known as FERPA, Family Educational Rights and Privacy Act. If you work as a school-based counselor, social worker, I've encountered instances where they think when they talk confidentially to a student, that's governed by HIPAA with regard to disclosures. Well, no, it's typically governed by FERPA, Title 34 CFR Part 99, not HIPAA. A lot of confusion about that, and that's important for school-based personnel to know. We have a number of people working in hospitals and healthcare facilities, and again, the proverbial other. Okay, let's go back. Next question. Actually, you're going to see three of them combined here on the screen, so please scroll through. You're going to see three of them combined. Okay, for the first one, are you currently providing behavioral health services to clients remotely or virtually using video counseling, telephone counseling, or text-based counseling? The second question on this screen is, if yes, if you are providing services remotely, which of the following technology options are you using to provide those services remotely or virtually? And we're all familiar with these now: video, telephone. Some of you may be using text to provide services, email to provide services, or it may not be applicable. And the third question on this screen, if you are currently providing behavioral health services to clients remotely or virtually. And please be candid. If you're not answering yes, no problem. Please be candid. If you're currently providing behavioral health services to clients remotely or virtually, have you created a consent to treat form that specifically, and I highlight the word specifically, addresses potential benefits and risks of remote and virtual counseling services? In other words, you are not using the traditional, you've been using it for years, consent to treat form that you've been using to provide face-to-face services. What we're talking about is developing and implementing a different consent to treat form, document, protocol that is specifically tailored to the remote delivery of services. So those are the three questions. Again, I'll wait another minute or so before I share the results. And while we're waiting, you'll notice that already several times I've used the noun client to refer to the recipient of services. I recognize that some of you work in settings where the noun is patient. You may use that in your private practice. Some of you, psychiatrists would say patient, typically not client. Some of you are working in hospitals and healthcare facilities. You would use the term patient. Rather than say client and patient all day long, I'm going to use the word client, but please know I'm including what many of you would refer to as a patient, a recipient of service. Okay, I'll cut this off in just a moment. All right, I'm going to end it there. I know some of you haven't answered, but we have enough to get a sense of what's going on here. So, interestingly, a little over 2/3, little under 3/4 of you who responded are providing services remotely. My guess is some of you were doing that before the pandemic fell out of the sky 3.5 years ago. Yes, it's been 3.5 years. And that many of you really started to provide services remotely when the pandemic arrived. And we're going to talk some about the ways in which a variety of ethics and risk management issues have emerged primarily because of the exponential growth in behavioral health professionals' use of technology to deliver services remotely. I should have added in my little intro, I also, in addition to chairing the national task force that wrote the Code of Ethics for the social work profession, have chaired two other task forces, one international from people all over the world, one US based, to develop a state-of-the-art ethics-informed standards regarding practitioners' use of technology to provide services remotely, to communicate with clients using digital technology, to store information in the cloud, to handle online social networking, lots and lots of issues. So that will come up today as well. And you can see on the screen that the majority of you who are providing services remotely are using video. That's not a surprise, but many of you are using telephone. 52 of you report using texting to provide clinical services. We're going to talk about that and share some cautionary thoughts with you. Some of you are also using email. There too, we're going to share some cautionary words about some of the risks we've encountered associated with the use of text and email. Okay. All right, let's go to the next question. There are two of them on this screen. Are you currently using an electronic health or medical record to document services? I'm guessing that when many of you started your careers, there was no such thing as an EHR or an EMR, but now there is, of course. And the second question here is, if you are, and please read this carefully before answering, okay? Because there's a term here defined by law. If you're using an electronic health or medical record, does it include a separate tab or field labeled psychotherapy notes? Not psychotherapy progress notes, not psychotherapy casework notes, but those two words, psychotherapy notes, which is a defined term in the law. So if you are using an electronic health or medical record, does it include a separate tab or field labeled psychotherapy notes, quote unquote, that's separate from a tab or field for more routine clinical or progress notes? So one tab, a typical session note, clinical note, progress note. Another tab labeled psychotherapy notes. Okay. Yes, no, don't know. And again, we'll wait just another minute or so. You'll see in just a moment that one of the issues we're going to talk about is the extent to which clients have a right to electronic records, since many of you are using electronic records. And Bob's going to talk about a very strict federal law, or fairly recently enacted law, that addresses this very issue. Okay. Give it another 30 seconds here. All right, I'll stop it there. And you can see that nearly 3/4 of those of you who responded are using an EHR, EMR. So what Bob has to say about the fairly recently enacted law, federal law pertaining to client access to electronic records, is particularly important. And both of us are going to talk about some of the problems we've seen with use of EHRs and EMRs, things like copying and pasting notes without proofreading them carefully. We both have a number of stories to tell about things that have gone awry. And 288 of you report that you do have a separate tab in the electronic record labeled psychotherapy note. 344 of you say no, and quite a few of you say don't know, which is fine. We're going to talk about that. Okay. We have a few more questions. Thank you for your patience. If you have been providing services, there's only one question on this screen. If you have been providing services remotely during the COVID-19 pandemic, and you've returned to in-person practice, have you done so completely, partially, or not? It's not applicable. It doesn't apply to you. If you've been providing services remotely during the pandemic, and you've returned to in-person practice, have you done so completely, partially, or not applicable? Thank you for responding so quickly. I can tell people have gotten used to this. You're pretty good at this. So, again, thank you for your patience. I'm going to stop it there in the interest of time. And you can see that 160 of you who responded report that you have returned to in-person practice. 400 of you partially. So I'm guessing you're seeing some people face-to-face, some people remotely, maybe alternating kind of hybrid style. We're going to address some issues related to COVID because the pandemic, interestingly, has introduced some never seen before ethics and risk management challenges. I would say related to two things, privacy, client privacy, but also your privacy. Like, what if a client asks you whether you've gotten the most recent vaccine because you're sitting in a small office, meeting in person, no ventilation or not much, and also boundary issues, self-disclosure issues, which we'll talk about. Okay. Now we've got two more. Again, please be candid. No problem if you're not familiar with this. How familiar are you with the federal law entitled the 21st Century Cures Act? The federal law entitled 21st Century Cures Act, which includes provisions governing behavioral health providers' obligation to enable clients access to their electronic records. So if you're not familiar with it, fine, you will be by the time we're done today. This very strict federal law, 21st Century Cures Act, that includes provisions governing behavioral health providers' obligation, and that word we're using very deliberately, obligation under the law, to enable clients access to their electronic records. I'll give it another minute. Let's end this in the interest of time. And folks, this is why continuing ed, even though it may seem onerous and inconvenient and even annoying at times, is really important. So only a handful of you are very familiar with the 21st Century Cures Act. 217, some are familiar, but the vast majority of you, about 3/4 who responded, are not familiar with this. And Bob and I think you need to be familiar with it. You will be by the end of the day. And we have one more question. Again, thank you for your patience with all this, but it's really helpful to us. Again, please be candid. How familiar are you with the federal law entitled No Surprises Act of 2022? So you can see it's a little over a year old. How familiar are you with the federal No Surprises Act of 2022, designed to protect clients from receiving surprise bills, quote unquote, surprise bills for services rendered? How familiar are you with the federal law entitled No Surprises Act of 2022, designed to protect clients from receiving surprise bills for services rendered? We're almost there. All right, I'm going to stop it there in the interest of time. And only 15% of you who responded said you're very familiar with the No Surprises Act. About a third of you somewhat familiar, but over half of you not familiar. And this is another one, especially since so many of you are in private practice. It applies to others as well. This will be really important information. Maybe not exciting, we get that, but important. All right. So for those of you who came in a little bit late, here's how it's going to work. I'm going to now dive into substantive material. That will take us up to the first break. The first break will be in a little over an hour or so, 15-minute break. When we return, Bob will pick up. He will present up until the lunch hour. He will then continue after the lunch hour up until the mid-afternoon break, and then I will finish up. Okay, so that's how it's going to work. And Bob, did anything jump out at you with the polls that you want to comment on before I do my thing?
No, thank you. I think we're all set.
Very good. All right. So what's a webinar without a PowerPoint? Gotta have a PowerPoint. Here's the PowerPoint. Again, we have two PowerPoints. This is the one I prepared. Bob will put his up when it's his turn to present. And when the Q&A feature is activated, while I'm talking, Bob will monitor the Q&A, and he will be very selective. We have such a large crowd today that it's impossible to respond to all the questions, but he will pick out the ones that seem to have the broadest appeal. He may answer some of those online, like typing, and he may choose to share some of those with us live, so to speak, when I give him the cue to do that. And then when Bob is talking, we kind of switch roles. It's kind of like tag team wrestling. And when he's talking, I'll monitor the Q&A and I'll answer some online, save some to share live with everybody. Okay, so here we go. Thank you again for your patience. So Bob and I have 6 things in mind for our time today. Here's what we want to do. We want to talk about ethical challenges and risks in behavioral health. And I highlight the word challenges. We're not going to be spending a lot of time on the easy stuff. We know that many of you, I'm guessing most of you, have sat through all kinds of ethics trainings required by your licensing boards over the years, or just your employers have required it, or what have you. And you don't want to hear same old, same old. So we're not going to be spending a lot of time on the easy stuff. We're going to be spending a lot of time on challenging, difficult stuff, challenges. Number 2, Bob and I, during our combined 80 years, I guess that makes us like geriatric presenters, our combined 80 years of work related to the topics we're addressing today, risk management. We're going to be sharing with you lots of tips that we've learned during our combined experience. And we have a lot of tips to share. Tips to prevent, notice the word prevent there in number 2, to prevent licensing board complaints and lawsuits. We think so many of the problems he and I see can be prevented. Number 3, we're going to talk some about technology. I've already alluded to this, the ways in which, especially because of the pandemic, although some of this preceded the pandemic, the ways in which behavioral health practitioners are using technology to do several things: to serve clients remotely, to communicate with them using text and email, sometimes online social networking. No kidding, it's happened. And the use of electronic records to store very sensitive information, which brings up lots of ethics and risk management issues about firewalls and encryption and who should have access to these records. And what about the 21st Century Cures Act that Bob's going to talk about? Lots of stuff related to technology. Just as an aside, I'm now involved in a project that is developing ethics guidelines for behavioral health practitioners' use of artificial intelligence. So even if you've gone to lots of ethics trainings, I bet you've not gone to any that have brought up the issue of artificial intelligence, because it's a relatively new issue. And I'm now involved in some really complicated discussions, the goal of which is to develop some ethics-informed guidelines for behavioral health practitioners who are using artificial intelligence to diagnose clients' issues, to give clients advice using artificial intelligence, to generate clinical notes, honest to goodness, generate clinical notes using artificial intelligence, and so forth. Who could have imagined this when we started our careers? But here we are. Ethics is a moving target. Risk management is a moving target. It's not always same old, same old. Number 4, Bob and I are going to share some pretty challenging scenarios with you that require careful, exquisitely skillful decision-making. That's number 4. So particularly this afternoon, we're going to sprinkle it around, but particularly this afternoon, we're going to talk about a framework that we think can be really useful in an effort to recognize ethics and risk management problems and try to snuff them out before they become big problems, analyze really complex case scenarios, prevent problems. That's what we want to do with this ethical decision-making framework. And then number 5, that dreaded 5-syllable word for so many behavioral health practitioners. What is the dreaded 5-syllable word for many behavioral health practitioners? Documentation. Count them, 5 syllables. We know, we're not naive, that for many, not all, but for many behavioral health practitioners, documentation is either the least favorite part of the work they do or close to the bottom of the list of favorite things to do. Let's face it, it's time consuming, it's onerous, it's tedious. We don't get reimbursed for it typically, if you're in private practice, let's say. But here is what Bob and I have learned so many times in our careers. And we're not saying this because, oh, you just got to say this. We're saying it because we have lived this. That the quality of behavioral health practitioners' documentation is vitally important. And heaven forbid, you should be named in a licensing board complaint or a lawsuit. This is the factual reality. The outcome of that licensing board complaint, the outcome of that lawsuit, litigation, will be determined to a great extent by the quality of your documentation. And that's not an exaggeration. That is not hyperbole. That is a fact that Bob and I know. We will tell you stories of practitioners with whom we have dealt, Bob representing them as a defense attorney, me as the ethics consultant or, quote, expert witness, unquote, where we review every clinical note, every psychotherapy note, every electronic record entry, every text message, every email message that's relevant to the case. And it's all fair game. In federal court proceedings, lawyers follow what's called the Federal Rules of Civil Procedure. Well, rule number 34 pertains to lawyers' access, lawyers' production of what's called ESI, electronically stored information. Rule 34, when it was originally drafted decades ago, said nothing about electronically stored information. It had to do with like paper records, letters, calendars, bank checks, physical hard copy documents, and what lawyers call tangible things. That's a lawyer term. But now Rule 34, and there's a comparable rule at the state level typically, includes references to ESI. And the cases that Bob and I get involved in produce lots of evidence. And that evidence now typically includes text messages exchanged with clients, email messages exchanged with clients, online posts on Facebook, LinkedIn, et cetera, et cetera, et cetera. We see all this stuff under the heading of ESI. Technology has transformed documentation, and Bob will tell you that when he gets involved in a case representing a client, he needs to see everything. Everything. If you have Post-it notes stuck in the file with doodles on them, he needs to see them. Everything. Because he knows that high quality documentation can often lead to a good outcome. But Bob also knows as an attorney that the other side of that coin poses problems. And he and I both see too many instances. And I'm sorry if this sounds a little pedantic, but this is just the reality. We see too many instances where notes were not carefully written, they were not proofread, they contain errors, there were late entries. There are problems, major problems with the documentation. We can't make that problem go away. Once you ring that bell, you can't unring it. And problematic documentation often leads to a bad outcome in litigation and licensing board cases. So as unpleasant as that 5-syllable word is, it is really, really important. And finally, number 6, you'll see in the middle of that sentence a 3-word phrase, standard of care, standard of care. Bob's going to talk a good bit about the concept of standard of care, which in the law is a central pillar when there are litigation cases. I'm going to talk about standard of care with regard to ethical decision-making for risk management purposes. Those 3 words, standards of care, are critically, critically important. Okay, so disclaimer time. Today, my comments will include references to relevant laws I've already referred to: HIPAA, FERPA, 42 CFR Part 2, the military rules of evidence at the federal level, and Bob and I have both made reference to state laws. Today, my comments will include references to a variety of laws, statutes, regulations, case law, I already mentioned Tarasov, and legal concepts. That said, I am not an attorney. Bob is, I am not. I cannot offer legal advice. My advice is limited to ethical and risk management issues. So if you feel the need for legal consultation on these and related issues, please consult an attorney licensed in your jurisdiction with Bob's expertise, which not all attorneys have, expertise pertaining to the topics we're addressing. And finally, I'm not aware that I have any conflicts of interest pertaining to my presentation. Okay, so let's just get some issues on the table, or more precisely, on the screen. Just to give you a sense of the kinds of issues we're going to talk about, this is not a pretest in the formal sense, but it's kind of a conceptual pretest. Like, what do you know at this point in the day? First bullet point. How confident are you at this point in the day that you know the differences between subpoenas and court orders? When an attorney like Bob requests your records in a legal matter involving your client, particularly when information in your records could be used against your client. So those words, subpoena, court orders, are those synonyms to you, or are they different? Well, the reality is they're very, 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 very different. And our obligation, ethically and legally, is to respond to subpoenas of our records very differently than we respond to court orders. Important to know the distinction. I'm not going to explain all this now, but that's coming later. Bullet point number 2. How familiar are you with the term privileged communication, and that it is not a synonym for the term confidentiality? They are not the same thing. The rules governing privileged communication when behavioral health practitioners provide services to clients who share information confidentially are very different from more general, broader confidentiality rules and guidelines. So Bob's going to talk specifically about the concept of privileged communication and its implications, particularly if there's a request for your records. Bullet point number 3. How knowledgeable are you at this point in the day about how federal laws such as HIPAA, Title 42 CFR Part 2, that's the substance use disorder treatment patient confidentiality guideline law, FERPA, pertaining to school counselors and social workers, federal laws pertaining to behavioral health practitioners who work in the VA or for one of the military branches, how those federal laws and your state laws. So if you're in Wisconsin, there are laws governing behavioral health practitioners. If you're in Mississippi, there are laws governing behavioral health practitioners. If you're in Florida and Missouri, et cetera, et cetera, et cetera, what's the relationship between those federal laws and those state laws? How are they similar? How are they different? What do you do if they conflict, which they sometimes do? 4th bullet point. One of the poll questions had to do with the term psychotherapy notes. So at this point in the day, are you familiar with how HIPAA defines the term psychotherapy notes? And that's where it is defined. It's defined in HIPAA, kind of buried in there, and how a psychotherapy note under the law is treated very differently from a routine clinical note or progress note, especially if there's a request for your records from a client, from an attorney. Got to know this. That's why we asked the poll question. Bullet point number 6. The relationship between federal and state laws when adolescent clients, and I'm guessing a number of you provide services to adolescents, and even if you don't, this is a good teaching example. The relationship between federal and state laws when adolescent clients seek substance use disorder treatment and do not consent to disclosure of their request to their parents or guardians. So, for example, the parents may know that the kid is getting mental health counseling, but suppose during that counseling, there's evidence of substance abuse, and the therapist is able to get the kid services to address the substance abuse in the mental health center, because there's a federal grant. You don't need the insurance card. There's no explanation of benefits that's going to go to the parents. And suppose the kid is really fearful that if the parents find out he's struggling with substances, they're going to go into orbit, and the kid feels afraid. And we know this happens at times. And the kid wants the help, but does not consent to the disclosure of that information to the parents or guardians, right? Do you know how to handle that? What Title 42 CFR Part 2 says, and it addresses that issue in Section 2.14. If you're keeping score, that's where it is, Section 2.14. And the relationship between what the federal law says and what the state law says, and fun fact, state laws on this issue vary considerably. The state laws governing delivery of services to minors for substance use related issues without disclosure to the parent or guardian, those laws differ dramatically state to state. Right now, Bob and I are in Rhode Island. Just to the west of us is Connecticut. About 8 minutes driving time from where we're sitting is Massachusetts. We have Connecticut and Massachusetts very close by. If you line up Connecticut, Rhode Island, and Massachusetts law on this very issue, they are completely different, completely different. Practitioners need to know these things if the issue is relevant. The next bullet point. We imagine that a number of you have had clients who have moved out of state, Perhaps they moved out of state because of the pandemic, or they got a new job, or they got married, or got divorced, or whatever, and they want to continue working with you remotely. They don't want a new therapist because they have a relationship, a therapeutic alliance with you. Well, are you familiar with the rules governing provision of behavioral health services remotely across state lines, across jurisdiction lines, even internationally? You have a client who's going to spend 6 months in Paris, kind of thing. And these rules have changed considerably even since the beginning of the pandemic, and it's complicated. And not only do clients leave the state, but sometimes the practitioner leaves the state and decides to spend a month in Arizona during the winter or in Florida, and they want to continue providing services to their clients back in the state where they are licensed. But they may not be licensed in Arizona or Florida, and this is complicated. The next bullet point, one of the other poll questions had to do with the 21st Century Cures Act. That's the very strict federal law governing clients' right to access your electronic records, if you have electronic records. Are you familiar with that? We know from the poll responses that a number of you are, but many of you are not, but you will be by the end of the day. Same thing with regard to the next bullet point, the No Surprises Act, having to do with what are called GFEs, good faith estimates, that under the law, practitioners are obligated to provide clients with regard to the likely cost of services. The next bullet point, professional will. Now, I'm guessing that many of you have a will. It's not a pleasant subject, but many of you probably have a will, a traditional will. But do you have a professional will? Especially those of you in private practice, which is a very large percentage of you. Do you have a professional will? Are you familiar with it? Do you know what it includes? Do you know why you need to have one? Bob's going to talk about that. We talked about one of the poll questions. We talked about how important it is, in our opinion, to have a consent to treat protocol when you provide remote or virtual behavioral health services. That, in our opinion, you should not be relying on your traditional consent to treat protocol that you've been using for face-to-face services. We'll talk about that. The pandemic, as I mentioned a while ago, it has introduced some really novel ethical and risk management issues. With regard to clients' right to privacy, the right to face-to-face treatment, if they insist on it, but you're not comfortable doing it, what's the law on that? What are the ethics on that? Clients who ask you about your vaccination status, that's introduced some really challenging issues related to self-disclosure. Next slide. So, as I mentioned, I have also, in addition to chairing the national task force that wrote the Code of Ethics for the social profession, I've chaired one international and one national task force to develop ethics-informed standards pertaining to the use of technology to serve clients remotely, to communicate with them between sessions, to store information electronically, to search online for information about them without their knowledge. There are now national standards regarding all these issues that probably didn't exist when most of you finished your formal education. Many of you perhaps work in integrated health and behavioral health organizations, the next bullet point, where in that building or buildings, there's not only behavioral health care, but there may be primary health care. There may be dental services, maybe services for people who are struggling with housing and insecurity and so forth. And we think it's really important to have risk management protocols in place to protect the privacy of the behavioral health records when lots of non-behavioral health professionals in that organization might be able to access your notes. It's especially important if your notes are governed by 42 CFR Part 2. The third bullet point on this slide. If we were sitting in a room together, I'd ask you to raise your hand if you've ever had a client who's disclosed that he, she, or they has ever committed a very serious crime, and they want to talk about it. It's part of the therapy. They feel guilt. They feel remorse. They want to process all this. They want to make amends. Well, suppose this is a crime for which they've never been arrested, never been charged, never been convicted, never been sentenced. In other words, the police don't even know about it, but you do. Well, suppose that crime that was committed 7 years earlier was a murder, and this is based on an actual case. Suppose you had a client who disclosed to you that he or she or they committed a murder 7 years ago. You don't think they pose a risk today. They're in recovery. They were under the influence, reportedly, 7 years earlier. But now you know from them that the client committed a murder. What are the rules around disclosure? Does that fall under duty to warn, duty to protect? What would you put in your case notes? Would you document the fact that your client told you this? And one of the things I argue, I'll make a little editorial comment here, is I believe the phrase confidential case record, and that's a phrase many of us have used, confidential case record. I think that phrase is complete fiction. I don't think there is such a thing as a completely confidential case record. I can rattle off dozens of ways, literally dozens of ways, in which what we think are confidential records are not necessarily confidential. They can be disclosed for a variety of reasons without client consent. They can be accessed by third parties under a variety of circumstances without client consent. So I tell my graduate students, every word you type, every word you write, if it's a paper record, write it assuming third parties may access those notes. Are you comfortable with the wording? How much detail you've put in there, when you've been vague, when you've not been vague? And I think that's critically important in this scenario where a client discloses, for example, that he committed a very serious crime years earlier. You've all heard the phrase, duty to warn. Many people use it. I typically don't use it because if you take a look at the major court decisions around this so-called duty to warn, they're very clear. The duty is much broader than duty to warn. It's what the courts have called duty to protect. Duty to protect. And we're going to talk about that. That warning is one way to discharge that duty, but not the only way. I prefer the phrase duty to protect. And do you know what the law is in your state with regard to the so-called duty to protect? So if we have time later, I will show you a map. And the map includes 4 colors. It's a color-coded map. One color is used for states where their legislatures have concluded that behavioral health practitioners who have evidence that a client poses an imminent, serious, and foreseeable threat of harm to a third party, in those states, the law says you have an obligation to disclose without client consent. That's color code number 1. But other states are coded in a different color, and their laws say something very different. Their laws do not say you're obligated to disclose when there's evidence of imminent, serious, foreseeable harm that might be perpetrated by your client. Those states' laws say you're permitted to disclose, not obligated, permitted. That's a huge difference. Where Bob and I are in Rhode Island, the law permits disclosure. But about an 8-minute drive from where we're sitting in Massachusetts, the statute mandates disclosure. That's category 2. Then there are 4 states in the United States that don't have a statute on the books. That's group number 3, color number 3. And then there's one state, Georgia, if any of you are in Georgia, that has different guidelines for different behavioral health professions on this issue. I don't fully understand why, but that's how Georgia has chosen to handle it. And we have to know these things. Next bullet point. Earlier, I mentioned malpractice coverage. So if we're in a room together, and obviously we're not, I would ask. Well, first of all, let me say, I know many of you are private practitioners. I will assume all of you have very good malpractice insurance. Although, do you have enough insurance? Do you have the right kind of insurance? Bob's going to talk about that. Do you have what we now call cyber liability coverage? CYBER, not PSYBER, CYBER, cyber liability coverage, because so many of us are using technology, right? We're storing sensitive information in electronic records. There could be a HIPAA breach. We have stuff on flash drives, stuff in the cloud, all kinds of ways in which there can be problems. So I now recommend that people get cyber liability coverage as part of their policy. But many of you are working for employers. You're not in private practice. You're working for school districts. You're working for hospitals, working for a Department of Corrections, let's say. And you may be relying on your employer's insurance coverage in the event that you get named in a lawsuit, which statistically is not that likely. More about that in a bit, but we know it can happen. And so I would ask, let me rhetorically, because we can't see you, how many of you are not in private practice? You work for a hospital, mental health center, school district, the military, the VA, whatever, Department of Corrections, and you rely on your employer's malpractice coverage in the event there's a problem involving you. And I bet a number of you would say, yep, that's me. Well, Bob's going to give a little speech. And I can, whoa, a lot of hands, a lot of thumbs just went up. So Bob's going to give a little speech. I'll give a shorter speech having to do with our firm belief. And we hope you're convinced that even if your employer, for those of you not in private practice, has really good coverage, do not rely on it. Get your own individual coverage. Bob will explain the reasons why. We're not here to try to get you to spend money unnecessarily, but I will tell you, as a behavioral professional employed by an organization, I would not work for 5 minutes. I wouldn't work for 2 minutes without my own coverage. And there's several reasons why, which Bob will go into. And it's a big mistake that a number of our colleagues have made, not having their own coverage. Next bullet point. We're going to talk today a lot about lawsuits. We're going to talk a lot about licensing board complaints. P.S. We don't want your blood pressure to go up. That's not our goal. We don't want your anxiety to go through the roof. That's not our goal. In fact, it's just the opposite. We want to give you information to try to lower your blood pressure, lower your anxiety. That's what we're trying to do here. But Bob spends an enormous amount of his time as a lawyer representing behavioral health practitioners just like you who've been named in lawsuits, who've been named in licensing board complaints. There are different legal standards. It could be the exact same case. I'm right now involved in 3 different cases where a disgruntled client or a client family member has filed both the licensing board complaint and the lawsuit. It's the exact same set of facts, but the legal standards in a lawsuit are not the same as the legal standards in a licensing board complaint. And Bob will talk about that. The next to last bullet point, and then I'll be done with these. So I mentioned a little while ago that one of the most recent ethics and risk management challenges to emerge pertains to practitioners' use of artificial intelligence. If we had had this discussion a year ago, I wouldn't have brought it up. That is how current these issues are. So I know, because I'm involved in a project addressing these issues, that a number of practitioners, maybe even some of you, are using artificial intelligence in the form of chatbots, speech recognition software, what's called EMA, this is a mouthful, ecological momentary assessment. In other words, a client who in real time reports his, her, or their moods, his, her, or their thoughts. In real time, an artificial intelligence interprets that data. Ecological momentary assessment. It's quite a phrase. We know there are practitioners using artificial intelligence. They're using it to provide services to clients, to diagnose them, to provide crisis intervention, and most recently, I was involved in a discussion regarding a particular product that's on the market. I'm not going to name it because, frankly, I don't want to endorse it, where clinicians have the option for a fee to record clinical sessions with client consent, presumably, upload the recording to the cloud, and this artificial intelligence software will generate the clinical note for the session. What do you think about that? This is happening, folks. And frankly, I'll show my cards here. It makes me extremely nervous. It makes me extremely nervous. I would not endorse that, but people are doing it to save time, right? And then finally, the issue I mentioned earlier, standard of care. To what extent are you truly familiar with the concept of standard of care? Bob, let me pause here. Anything come up in the Q&A that you'd like to share?
You would believe the number of questions that have come up, but at this point, why don't you continue? And I'm trying to parse through these.
Is there an overwhelming theme, or are they all over the place?
There's numerous topics.
Okay.
All
right.
We may want to. You may want to curtail some of the things you cover a bit to allow more time for questions.
Got it.
Let's put it that way.
Got it.
Okay.
Okay. So, folks, just so a heads up, we're going to aim to take a break in a little more than a half hour, so you can look forward to that. Okay. So I am going to streamline some of what I would ordinarily say, so that we have some time for Bob to share some of these questions. So very briefly, what you see on slide 7 is a timeline. And this is my assessment of the evolution of ethics in behavioral health. That, in my opinion, we've gone through 5 stages. And I'm not going to take the time to go through the 5 stages. That's kind of a history lecture. But let me just make a couple of quick points here. What we now call behavioral health. And of course, even that is a more recent term. Got started in the 1800s, right? Psychology and social work, especially in the 1800s. During those years, there was no discussion of the issues we're talking about today. Even up through the 1970s, the bottom left of the timeline. If you look at the literature in the professions represented here today, social work, mental health counseling, marriage and family therapy, psychiatry, psychology, and so forth and so on, most of that literature focuses on what are the core values of the professions. No in-depth discussion of ethical dilemmas and risk management. That doesn't start until, this is the middle of the timeline at the top, the 1970s. That is when it started. When a relatively new field, I imagine many of you know the term bioethics, especially in medicine. In the 1970s, there's no question about it. This is when it happened for a variety of reasons, which I could talk about for about a half hour, but I won't. For a variety of reasons, in the early 1970s, professionals, health, and some behavioral health, but mostly healthcare, professionals recognized there are some really complicated ethical issues, end-of-life decisions, and issues around reproductive rights, and issues around organ transplantation, and genetic engineering and genetic testing, all these complicated ethical issues. And in the early 1970s, a relatively small group of professionals in healthcare, especially, joined forces with philosophers, moral philosophers, who up till then, tended to focus on Socrates and Plato and Aristotle and John Stuart Mill and Jeremy Bentham and Immanuel Kant and people like that. All of a sudden, there's this new field called applied ethics, professional ethics, applying ethics concepts to the very practical challenges arising in healthcare. And that's when I sort of discovered this whole phenomenon. As I mentioned at the beginning, I was working with this inmate in a federal prison in Illinois. I had to make this very difficult decision about that inmate's confidentiality rights and exceptions. And I'm, at the time, a PhD student at the University of Chicago, and I'm thinking, whoa, there must be guidance on disclosure of confidential information without client consent. And I went to the library, and by the way, then you had to actually go to the physical library, and there were these things called card catalogs. Anybody remember those? May they rest in peace. There were things called stacks. You actually had to go into the stacks to find journal articles. May they rest in peace. No electronic anything. And that's when I discovered that there was this brand new field, especially in medicine and healthcare, called bioethics. And I'm thinking to myself, whoa, we ought to be doing the same thing in the behavioral health professions. And it happens that there was a small group at the University of Chicago that was into all this stuff. And that's when I sort of got on this train thinking, this is really challenging, exciting stuff. And that's how I got involved in all this in the late 1970s. Not 1870s. Some people think I did it in the 1870s. It was 1970s, just to clarify. And for years, my work focused on ethical decisions, ethical dilemmas. My first book came out in 1982, and the word lawyer, the word lawsuit, the phrase licensing board complaint, those words don't appear in that book because I wasn't concerned about that. I didn't become concerned about that until, bottom right of the timeline, early 1990s, October 1990. When I got my first call from a lawyer working at a law firm in Charlotte, North Carolina, called up, I answered the phone, Dr. Reamer, hi, my name is, I'm a lawyer with the law firm of, and our law firm is representing the mother of a young man who died by suicide, and we'd like to know if you'd be willing to review the records. We'd like your expert opinion. I didn't know what an expert witness was at that point. This is October of 1990. And that's when I discovered that, the law and ethics can intersect, particularly around litigation matters and licensing board matters. And if you do the arithmetic, I've now spent more than 3 decades dealing with these issues. Not a single month has gone by in more than 3 decades when I've not been asked to get involved in a litigation or licensing board case. So that's why I began to think about risk management. And then the top right of the timeline, if you had told me at the beginning of my career that in 2023, I'd be talking about ethical issues involving the remote delivery of services to clients that practitioners never ever meet in person, I would have said, you got to be kidding. What? Oh, and by the way, ethical standards had to do with this thing called Facebook. What is that? And what about searching online using a search engine? At the beginning of my career, I would have said, what's a search engine? None of this stuff existed. Of course not. For many of us who are here today, when we started our careers, a tweet was simply the sound a bird made. That was it, not something associated with what used to be called Twitter until recently, now called X. When many of us started our careers, the cloud was nothing but the white fluffy thing in the sky. That's all it was. But now it's where behavioral health practitioners store their electronic health and medical records, and there are lots of ethical issues associated with that. When many of us started our careers, TikTok was simply the sound a clock made, end of story. Now it's an app on many of your smartphones. And there's a fairly recent Washington Post article that discusses a clinician who has recorded portions of clinical sessions and uploaded them to TikTok for educational purposes. Now, isn't that an interesting issue? My point here with slide 7 is that ethical issues have changed dramatically over time. Ethical standards have changed over time. And I didn't see most of this coming. But here we are. Here we are. And then, of course, artificial intelligence. Slide 8 is really important. So here we are at, almost 20 minutes past the hour. And so we've been at this for, a little over an hour. And I've already mentioned the subject of litigation, licensing board complaints, which I understand makes people very nervous. I get it. But here is the reality. And I hope you find this reassuring. This chart, this 2x2 chart, if this were a statistics class, by the way, I teach statistics, I'd call this a contingency table, a 2x2 contingency table. But for our purposes, it's just a table, a chart with 4 cells. And the vertical axis is the probability that anybody here today will be named in a lawsuit or a licensing board complaint. So most things in life, I don't know anything about, or I know very little about, but I know the data on this. The statistical likelihood that anybody here today will be named in a lawsuit or a licensing board complaint is relatively low. That is really good news, but it's not zero. And Bob spends an enormous amount of his time as a lawyer handling these cases as a defense attorney. There are a lot of cases out there. We want to try to keep that number as low as possible. The probability is low, the vertical axis. But then there's the horizontal axis, the impact. I don't know if any of you have ever been named in a lawsuit or a licensing board complaint, or you know a colleague who has. But here's my guess. They're not happy. Nobody who's named in a lawsuit is happy. Nobody who's named in a licensing board complaint is happy. I've never seen it. In fact, they're usually very upset. They call me and they're very upset. They call Bob and they're very upset. Sometimes the conversation goes like this. I didn't do anything wrong. They're accusing me of this, they're accusing me of that, and they misunderstood what I said. And okay, we'll deal with it. They're upset. And even if they did nothing wrong, the impact is huge. It's time consuming, it's onerous. Meetings with Bob, drafting responses, meeting with Bob, drafting another response, meeting with Bob, drafting another response. Sometimes you have to testify in depositions. You have to answer what are called interrogatories, part of the discovery phase of a case. Sometimes you have to testify at trial or at a licensing board hearing. Sometimes you have to be cross-examined by the lawyer on the other side of the case, opposing counsel. It is not a pleasant experience. We want to try to prevent that. So bottom line is, what Bob and I are doing today is the lower right-hand quadrant, Low probability, but the impact tends to be high. And we want to try to prevent both of those. Okay. So in a perfect world, not the one I live in, but in a perfect world, behavioral health practitioners would really master three things in order to keep that probability low of a licensing board complaint or a lawsuit and to manage it skillfully if it happens. Number one, really understanding ethical dilemmas, those difficult choices, not the easy stuff, the difficult choices. You're providing services to a minor client. The parents are involved in a child custody dispute. One of the parents or the parent's lawyer wants to see your notes to see if there's anything in your notes governing that could affect their assertions about the other parent. But your minor client doesn't want the parent to see the notes because they include some really sensitive information about the kid's sexual orientation or gender expression or whatever. I don't want my parents to know this. How do you handle that ethical dilemma? How do you thread that needle? Parents' right to know, the kids' right to privacy. I imagine all of you have been asked over time questions like this. How old are you? Where do you live? Do you have any children? Are you in recovery? Personal questions. You have to make decisions about self-disclosure, right? And I will guarantee you that many of you have had clients who've looked you up online and found out a lot about your life online. Because instead of asking, they do the Google search, the Bing search, or what I call the DuckDuckGo search. That's another search engine. And they're learning a lot about their clinicians. And you have to figure out how to manage those boundaries around disclosure and self-disclosure. I imagine a number of you live and work in relatively small communities, relatively small populations, where it's not a question of if you encounter difficult boundary and dual relationship issues, it's when. It's when. Your kids, your client's kid and your kid are playmates because they're in the same third grade class, and there's only one third grade class. And your kid wants your client's kid to spend the holiday weekend at your house. Oh, how do you manage that? There's only one person in town who can repair a car transmission, and your car transmission needs repair. And that person is your client. Your spouse or partner works with your client in this small community. How do you manage that stuff? You have a client who is a suspect or a fugitive in a serious criminal case, and a detective shows up at your door. They know that this individual was getting services from you because a family member of the client told the detective who went to the house. Detective wants information from you. How do you handle that ethical dilemma? Is it governed by HIPAA? Is it governed by 42 CFR Part 2? How do you handle this? Ethical dilemmas related to confidentiality exceptions, duty to protect, duty to warn, that kind of stuff, boundary issues, door relationships, conflicts of interest, documentation. If you believe me that there's no such thing as a confidential case record, ethical decisions about when to be vague in the case note, when not to be vague in the case note. And when these issues arise, the second tile there, ethical decision making. And I'll be focusing on that, especially this afternoon. And then the heart of today's discussion, ethics risk management. Making these decisions in a way that protects clients, always my first aim, and also prevents ethics complaints and lawsuits. And in my career, I have noticed three patterns. First, really dedicated, earnest, thoughtful, principled behavioral health practitioners who make mistakes, inadvertent mistakes. They send information via email. They shouldn't have sent it. They sent it away. It wasn't protected. Oops. They didn't manage boundary issues carefully. They made a mistake. Oops. They thought they were governed by HIPAA, not 42 CFR Part 2, but it turns out they were governed by 42 CFR Part 2, which is much stricter than HIPAA, and they shouldn't have disclosed that information to the detective. It was a mistake. Oops. They forgot to document in their case notes the fact that they consulted with a colleague about a really difficult ethics case. They consulted with the colleague, but they forgot to document it. And you have some lawyer on the other side of the case saying, well, if it's not written, it didn't happen, which is not true, of course. It did happen. But it was a mistake not to document the consultation. The second pattern, deliberate ethical decisions. These are the cases where there's a risk of a lawsuit, risk of a licensing board complaint, alleging that would allege that the practitioner didn't make the right decision. It was a very thoughtful decision about duty to protect disclosure, a very thoughtful decision about protecting a minor's privacy when the parent wants to see the records. It was a very thoughtful decision about when to be vague in case notes. But somebody alleges you made the wrong decision. It wasn't a mistake. It was just a disagreement about the judgment you exercised. That's the second tile, the green one. And then sadly, the third one, ethical misconduct. As you'll see in just a moment, and I'll be very quick so that Bob has time to share some questions here. Too many of the cases that Bob and I have been involved in. Bob is a defense attorney, myself as the ethics consultant or expert witness, involved pretty compelling evidence of ethical misconduct. The small percentage, and thankfully it's a small percentage, of practitioners who end up having sex with a client or sex with the former client not too long after they terminated services, or who billed an insurance company for clinical sessions that never happened, called fraud, and on and on and on. Ethical misconduct. Some quick examples, and then I'll turn it over to Bob. And I won't have time to get through all these examples. This is kind of like speed ethics. You know what speed dating is? This is kind of like speed ethics. So, a practitioner who worked for the VA who sent an email message she shouldn't have sent that had attachments she shouldn't have attached, making fun of veterans right before the winter holidays, exactly this time of year. Like, is it a good idea to send an email message with an attachment of a toy Santa with Christmas lights wrapped around its neck, making fun of Santa dying by suicide kind of thing, or another, a Christmas elf on its back, drug seeking, like some of our patients at the VA kind of thing? It was just a bad mistake. Or a clinician who posted comments on her own Facebook site about a client, didn't name the client, but included too much detail. And the client did a search and found that post and filed the board complaint. And the clinician got sanctioned. She made a mistake. The clinician in Maine, this is a screenshot of the licensing board website in the state of Maine. I testified in this case. as an expert witness who had late into the evening, night, online communications with an adolescent client on Facebook, private messaging. Extended, it was a clinical session on Facebook private messaging. And the kid's father ended up going through his daughter's Facebook site. I'm not defending that. I'm a father. I would like to think I wouldn't do that. But this father did. And he saw that entire clinical exchange, discovered things about his daughter he did not know until he read that exchange. And the dad filed the complaint. This guy, I think, made a mistake having a late at night online clinical session with an adolescent client on Facebook. And he got sanctioned very aggressively. This is a case I testified in Illinois. Look at that headline. The jury came back with a $45 million verdict. This is a very sad case involving an infant who was born testing positive for substances. The mother, one of the parents' of this child, she became the behavioral health client to work on her co-occurring issues, her trauma issues. And after 15 months, the behavioral health staff concluded that she had made so much progress, they were comfortable recommending to protective services and to the court that the child who'd been in foster care for 15 months with sporadic contact with mom for bonding purposes, that it was time to place this child, now 15 months old, with the mother, with supportive services. And that's what happened. And 3 months later, this now 18-month-old toddler was dead, allegedly murdered by his mother. And the surviving family members sued the behavioral health staff, alleging negligence, malpractice. I was on the witness stand for hours, and there were some serious documentation errors that I think led to that $45 million verdict. I think that verdict is to a great extent the result of documentation errors. These were mistakes. Good people made mistakes. Some of you recall that very recently in the news, an adolescent was sentenced to prison for, he was a high school student at the time of this incident when he shot and killed and injured people in Oxford, Michigan. And he had been interviewed by behavioral health staff that day before he was allowed to go back to the classroom. And he ended up pulling a weapon out of a backpack. This is the one where his parents are also charged. They are incarcerated right now as well. And these behavioral health staff in this school had to make decisions about confidentiality, what to disclose to school officials, allowing this kid to go back to the classroom, should they have said something to the police, protective services, all kinds of decisions. And right after this shooting, I was contacted by a Washington Post reporter who wrote this article that you see on the screen here about the decisions that have risk management implications. This is a case involving a decision about disclosure to law enforcement. This is from South Dakota. What do you disclose? What do you not? It's a decision. This is a Washington State decision that a psychiatrist had to make about disclosure of confidential information to protect third parties. And this psychiatrist decided in this case that he didn't have enough information to justify disclosure, didn't disclose. The patient, the psychiatrist patient, ended up killing 2 people. That's a decision that had huge consequences. I'm going to skip a couple of these. This is a New Hampshire Supreme Court decision having to do with a practitioner's decision about disclosure of her clinical records to the parents of her client, who's the minor, right? It's a complicated decision with lots of ethical and risk management implications. This is a case in Wyoming where I was an expert witness, where staff had to make decisions about documentation, very challenging decisions. They were prosecuted in federal court, and it is my opinion, which I expressed in this case, that their documentation decisions kept them out of prison. They were prosecuted in federal criminal court. This is a piece I wrote for a publication called Social Work Today, a decision about searching online for information about clients without their knowledge or consent. Later, I'll talk about the guidelines. This is an article from Forbes magazine about mental health practitioners using artificial intelligence, their decisions about that. And then finally, and then I'll turn it to Bob before we take a break. I don't want to dwell on these folks, but I think the graphic images hell a lot. Behavioral health practitioners who, end up being indicted, charged with fraud, defrauding insurers when they billed for services for addiction treatment. A behavioral health practitioner who is right now in federal prison because she falsified documents, she accessed information she shouldn't have accessed. She has a master's degree in social work, and she's now a federal prison inmate. And there she is, inmate 90889-509. This is a New Mexico practitioner sentenced to prison, sexual assaulting clients. This is a case I testified in for hours in Massachusetts as the expert witness for the Massachusetts Attorney General's office, where there were allegations of fraud involving a major behavioral health organization. This is a Wyoming practitioner sentenced to prison for healthcare fraud. This is a Pennsylvania case where a practitioner was sentenced to federal prison for falsifying records involving this child who died and was a client. And there's her prison face sheet, inmate 63849-066. She's still in prison. She's been there for years, graduate degree in behavioral health. This is a Utah practitioner sentenced to prison, sex with an underage client, and on and on and on and on. This one takes my breath away. A practitioner who worked for public child welfare and was sentenced to prison after she had sex with multiple minors who were clients. Child Protective Services. Takes your breath away. And on and on and on. This is a Michigan case I testified in, a clinician who worked in a trauma-informed care program, ironically, and ended up having a sexual relationship with 3 of his clients in a trauma-informed care program. I had to interview those clients. Those were painful, painful interviews. All right. You get the point. I don't need to dwell on all this. Bob, what would you like to share? You're muted, Bob.
We'll try to go over some of numerous questions that people are interested in before the break. We'll try our best throughout the course of the day to cover these topics. So one point that came up a few times deals with essentially those practitioners who work in rural or smaller communities, so that they're questioning whether there's sort of different rules that might apply and how to best address the situation. So this particular person's a mental health counselor, and said that the ACA Code of Ethics uses the language of boundary extensions and asks, is informed consent what covers us as professionals in that setting? So obviously, I'm not a clinician. I'll make a point or two and then turn it over to Rick. So I do think that the standard of care, which I'll address later, does depend on the context. And so there's much more likelihood in a rural or small community to have these issues occur. So I do think, in general, this is good advice to address at the very first session with clients, when you're in that kind of setting, how you might, interact outside of that setting, and what you would or wouldn't do to try to preserve confidentiality. And so it's always good to manage expectations, I think, from a risk management perspective up front. And so, yes, I think informed consent is important and addresses this. It's not necessarily going to insulate you from potential claims of breach of confidentiality, but I think it goes a long way. I think that you do not want to assume that because you're in a rural area that confidentiality doesn't apply, but it may well be that your client comes up to you and says, "Hey, I'm a client of so and so." I mean, they may waive it, but I don't think that opens the door to you trying to share information in front of third parties. Rick, what are your thoughts?
Well, okay, so I'll be very brief. In fact, we have another PESI training entirely focused on these sorts of boundary issues in dual relationships, where I can get into this in much more depth. But briefly, I agree with Bob completely that if one anticipates the possibility of some boundary and dual relationship challenges, it makes sense to acknowledge that upfront and to document the fact that you talked about it. Doesn't have to be a very long note. But we live in a small community. We may bump into each other, at church or at the supermarket, or our kids are in the same class. Let me explain to you how I will handle that to protect your privacy. Acknowledge it, talk about it, document it. But also, there are other contexts where these boundary issues become very challenging. So, for example, some of you may provide home-based services. You don't meet people in an office, and you may go to a home, and I'm a big fan of home-based services, and the only private space to talk with the client, because there's a lot of chaos in that home, is in a bedroom. Well, gee, think about the optics there. You go into a bedroom with a client and close the door. So, got to be very careful. As Bob said, different contexts have different boundary norms attached to them. Um, some of you may work in substance use disorder treatment programs where typically some of the staff are in recovery, and they may decide to disclose personal information about their own recovery as part of the model. Well, self-disclosure in a different context would not be appropriate, but in that context, it may be. And so I think one always has to factor in the nature of the treatment model, the nature of the clientele, the setting. Right now, I'll tell you this very quickly. I'm an expert witness right now in a case where a young woman died as a result of a drug overdose. She had a very long, complicated history, mental health struggles, and there's a negligence lawsuit. Part of the lawsuit alleges that the behavioral health clinician violated boundaries and privacy guidelines by having a number of meetings with this client in a restaurant. They're making a big deal out of this, the plaintiffs are. And my job is to say, well, wait a minute, take a look at this particular treatment model implemented by this program. They actually encourage clinicians to meet on occasion with clients in restaurants, sitting on a park bench, especially if the clients are not comfortable meeting in an office. It's actually part of the model. They have to take steps to protect privacy and all that. They have to, document what they're doing and why they're doing it. But I'm dealing with this right now in this case.
Okay, let's see if we can address another one quickly. So we talked briefly about the Cures Act that relates to access to electronic records. This person states that they don't have electronic records and they have paper records. And so when they get requests for these records, they typically just prepare a written summary of the treatment. And then they ask to be paid for their time to create that document. So I answered this a bit, but it seemed to be thumbed up by a number of people. So let me just elaborate a bit. So let's assume for the moment that HIPAA applies. And so not the Cures Act. So HIPAA applies to both electronic and paper records. In this case, we're assuming there are no electronic records. In general, clients in the HIPAA regulation are called patients, have a right of access to their records with the exception of psychotherapy notes, which I will describe later, a little teaser there for you. But it's an unusual situation where a clinician might say, I hear you'd like to get copies of your records. My practice would be just to give you a written summary. That's not something that, generally speaking, HIPAA would condone. There might be reasons, limited reasons why this might come up. For example, there might be some reason the clinician thinks it's counterproductive, maybe even harmful to share or disclose those records with the person. But even then, speaking with them about it and then explaining the risk and giving them the option of seeing the records is still something to consider. To take a hard and fast rule that I never or usually don't provide access, but I simply offer the possibility of a written summary and then looking for compensation, I think is problematic. Now, this particular questioner said they got paid by the insurance carrier, which surprises me. But generally, there's a right of access to the records, and you can't bypass this in that manner, in my opinion. Rick?
Nothing to add, just ditto.
Yeah. Okay. So I guess we're at the time for a break.
All right. So it is 15 minutes before the hour. We are going to resume promptly at the top of the hour. So have a good break.
Great.
And when we come back, Bob will be taking over.
All right. Very good. Okay.
Hello, everybody. Robert, if it's cool, I'll just do a couple quick reminders as well.
Sure.
Hey, everyone. I hope you're all having a fantastic day so far. Maybe you all were able to take a nice little 15-minute break, stand up, get a little coffee, stretch, get the energy moving, having a good time. I know I'm having a great time, so I hope you all are having the same great time. A couple updates and a heads up I want to give out. Lunch is at 12:50 Central Time. That will go till 2 p.m. Central Time. The mid-afternoon break, which will be another 15-minute break, is scheduled to be at 3:30 p.m. Central Time. And this training does end at 5 p.m. Central Time. So just make sure you keep those in mind, as well as obviously if you need to go use the bathroom, please do not wait for the breaks. Just go. So appreciate you all being here with us today. A couple other quick reminders, just because we do keep seeing questions. If you have any general questions regarding today's event, whether it's CE related or tech, please visit the FAQ page in your event portal that you use to access to launch this webinar. We have almost everything under the sun covered in there as well. And obviously a huge shout out to AJ, who is doing so much to help answer as many questions as he can in the chat. The Q&A feature is available. So many of you already taking advantage of it. Remember to keep those to content related questions. We have a very awesome and kind of unique experience here where Frederic and Robert are both personally answering the questions and typing them into the Q&A feature. So if you've asked a question, make sure to look, because it might be under the answered category by one of them, which is very unique and very cool. So huge shout out to them for doing that as well. As for CE, if you've purchased live CE credit, your live CE certificate and the post test will be made available at the conclusion of today's training. If you have not purchased CE credit, there is still time to do so. That can be done via your web portal. All registrants will have 14 days access to this. So if you miss something, don't worry. You can always go back. There's a lot of content here. There's no way I heard everything that happened this morning, so I can understand if some of you feel the same way. So you have 14 days access with or without paying. And if you want unlimited access, you could do the self-study upgrade as well. So I'll stop blobbing. Take it away, Robert.
Thank you, Spencer. Appreciate it. I hope you all are having as much fun as Spencer. I mean, that's just a great reaction. I know this can be a bit of a dry topic, and we're going to be getting through a lot of material. Unfortunately, we can't cover everything. You've come up with many good questions. We'll do our best to address them. Keep in mind that some of the things that I'll be covering both before and after lunch may well address some of the questions you posted earlier. So I'm Bob Landau. I'm an attorney. I'm in Providence, Rhode Island. I focus my practice on representing you in medical malpractice lawsuits, in licensing board complaints, providing risk management consultation. I represent both health and behavioral health providers. I've been doing this for 40 years. So let me put up my PowerPoint. And we will just start marching through. Okay, I have to start with a few disclaimers, as you might anticipate, particularly as a lawyer. So although I'll be addressing a lot of your questions, I can't really give you, strictly speaking, legal advice. We don't have an attorney-client relationship. Analysis of legal issues can be time-consuming and what we call fact-intensive. This is more in the vein of general guidance and principles of risk management. So the PowerPoint itself is not to be construed as legal advice. It's for informational purposes and to help you understand these issues better. And it's also a resource tool. It's possible that it's not the most up-to-date as well. And as I mentioned earlier, I'm not admitted to practice in most of your jurisdictions, but I do think nonetheless you will find this to be helpful. I don't believe I have any conflict of interest. You'll see that my slides tend to give as examples laws or regulations in Rhode Island and Massachusetts because I am familiar with them. But that doesn't make them irrelevant. And you'll see more as we go through this why that may be. But it is useful, I think, for you to start, if you don't already have, a healthcare attorney in mind to start thinking about how you might go about obtaining one. Word of mouth is really important. This is a really niche area of practice. It's a small area. Even in a large city, there aren't a lot of people who focus their legal careers to representing healthcare providers. So word of mouth can be really useful, and you can consult with your professional liability insurance company. You can consult with the local chapters of your professional organizations. And you can consider going online, but that can be a bit of going down a rabbit hole at times. So you have to be pretty specific. If you're not careful, you'll possibly end up finding plaintiff lawyers, and that's exactly the opposite of what you want to do. You want to ultimately be in a position where you're looking at the biographical information of that attorney, and you can tell that he or she defends healthcare providers, and specifically in the context of lawsuits and board complaints. And if you see that language, particularly if you see that name pop up in several sources, that would be reassuring. All right. I'm going to be skipping through a lot of my slides because we don't have a lot of time, and I just want to cover key points, and it's possible some of these points may have been covered previously. So risk management, I believe, can be thought of sort of in two directions, sort of forward and backward, prospective and retrospective. They're both important. I tend to focus my presentation on the prospective side. I saw that a number of you work at hospitals, and particularly there, but not limited to hospitals, they have risk management departments. And when adverse events occur, they often investigate, conduct what might be called a root cause analysis or a tap root analysis, and they try to identify what went wrong, what steps can be implemented to prevent that from recurring again in the future, possibly adding or revising a policy. And that's all well and good. But what I want to focus on are the steps you can take now to minimize the risk of you being sued or having a board complaint filed against you. Please understand there's no such thing as eliminating that risk. The most you can do is to minimize the risk. But I believe that if you follow the strategies that I will give through the course of the day, you will, in fact, minimize that risk. And in the event that you still are sued or have a board complaint filed, you will maximize your chance of a successful outcome. That's my goal. And it's certainly not to raise your blood pressure or anxiety. I recognize that's sort of part of what happens when we deal with these topics. Nobody relishes being in that situation. But particularly in the board defense arena, I would say, in my experience, certainly the vast majority of them get dismissed. And so it's not the end of the world if such a complaint is filed against you. Of course, it depends on the facts and circumstances. So one of my goals today, as perhaps scary as it might seem to you, is to sort of get you to think a little bit about these issues the way a defense lawyer does. And so if by the end of the day, that's where your head is going, you're starting to think about these issues the way I do, I would judge this to be a successful program. So we have to think ahead. If you do A, B, or C, what is likely to happen down the line? Are you going to position yourself in a positive way going forward or not? So I'll be giving you various risk management tools. And one of them, as Rick has alluded to, you'll see there's a lot of overlap in what we cover, is documentation. That is the thing that you have the most control over. And I know that it's also something that you probably don't like doing, and it's time consuming. And ironically, electronic health records were supposed to make documentation take less time. But in fact, for many people, it results in consuming more of your time. And you may think it's a waste of time. It is not a waste of time. If there's anything you take out of this today, it should be a deep understanding of the importance of documenting well and the consequences of documenting poorly. Now, there were a lot of questions about documentation, and I understand the impulse. Tell me, what's the perfect note? What should I do to address all situations? Unfortunately, it doesn't work that way. There's a lot of factors at work, and there's some tension in it. There's a balance to be struck between being concise and detailed, and it doesn't always work in the same manner. So in general, again, I'm not a clinician, but as a defense lawyer, in general, my preference is for people to be more detailed than perhaps they're used to being, because if it's well documented, it absolutely improves the chance of success. It may even result in a lawyer looking at your records and deciding, I'm not going to sue this person because the chart is so well documented. That would be the best possible outcome, but it can't happen if you don't take the time to do that. Now, as I said, I've been doing this a long time. I know that some of you, perhaps most, have been trained to document as little as possible, be as vague as possible. From my perspective, where I sit, that's terrible advice. Now, I'm not saying every detail has to be in there. This is obviously not a transcript of the session. And there may be times when being circumspect makes more sense. So Rick mentioned earlier a situation where potentially a client of yours confesses to having committed a murder some years ago. This is not the place to write down client confessed murder. There you have to be much more circumspect about what you write. Perhaps it'll be vague, like client disclosed a traumatic remote event that we spent time processing. But generally speaking, that's not going to happen. If you are treating a client who's presenting with suicidal risk or homicidal risk, you're going to end up having to make a clinical judgment. You're either going to decide that you're managing it sufficiently, or it's not sufficiently urgent for you to breach confidentiality, or you're going to be so concerned that you're going to notify third parties and you are going to breach confidentiality. Either way, your job is to document in a manner that a third party could read your record and see why you did what you did. Are you factual? Do you give reasons for your decisions? And can somebody determine exactly why you chose either to continue and keep confidentiality or to breach it? And did you support it with the right materials? The key is not that you're going to have a crystal ball and know what's going to happen down the line. Like it or not, there's some risk to the job and careers that you've chosen. The key is acting reasonably and then documenting the reasonable decision-making that you have undergone. And if you do that, it will help you. So that's risk management tool number one. Now, the second tool is consultation. This is extremely important. And the second piece of that is documenting the consultation. So sometimes I've come across people who might have said, look, I understand you're addressing a large crowd. Many of the people might be relatively new in their careers. I'm a veteran. I don't need consultation. Thank you very much. And I would say to you two things. First, perhaps a little humility may be in order, but second, more importantly, even if you consult expecting and receiving confirmation of your diagnosis and your treatment plan, the very fact that you did that and you documented doing it is a defense, an important defense, a valuable defense in a potential suit or board complaint. So imagine you've got this challenging situation, and many of these cases are, even if you are a veteran. You have a situation and you're not sure what you should do, or you at least acknowledge that what lawyers say, reasonable minds can differ. Not everybody's going to see it the same way. So if you were to consult with, say, two peers, and you briefly document, spoke with two peers about my diagnosis and my treatment plan, and they both concurred, that alone is very helpful to you. So what types of consultation are we talking about? Potentially three different types. Certainly the peer consultation is probably the most common and that you'll be using the most of the time. But in certain particularly challenging situations, you might consult somebody like Rick Reamer, who's internationally known as an ethics expert. And if you were to, let's say you have a confidentiality issue that you consult with him, do that, and then you're in a position to write, consulted with Dr. Frederic Reamer about this situation. He referred me to section 1.07C of the NASW Code of Ethics. We analyzed it, and based on this language, I believe we addressed the concern, and it details what you did and why. That's very powerful. Similarly, if you do that with a risk management attorney who is experienced in healthcare law, that too can be helpful. The only difference is you might be a bit more brief with your documentation of a consult with an attorney because you don't want to waive any attorney-client communication, which is otherwise privileged and confidential. So those are important, really important risk management tools. Now, even though we just started, I'm going to take a little break and talk to you a little bit about insurance. Rick mentioned this earlier. I don't have a conflict. I'm not a broker, but there's different types of insurance. And I want to talk to you mostly about the level of insurance that you have. So what we're looking at here happens to be an excerpt. And you can see here it involves psychologists. And you can see here it says policy declarations. We call this a declaration page. In this case, it's occurrence policy, occurrence insurance. Whereas here, same type of policy that is a declaration page, psychologist, but it's claims made. So what's the difference? The easiest way for me to explain this is to give you a brief example. So let's assume in 2022, one of your clients died by suicide. And in 2024, you are sued by the estate claiming wrongful death, malpractice, somehow stating you should have intervened. Perhaps you believed it was not necessary. Obviously, you didn't have a crystal ball. It turned out that the person died by suicide. Now, if you had an occurrence policy in place in 2022, even if you had no policy at all in place in 2024, you would still be covered because of the nature of the insurance. You need to have it in force at the time of the incident. The opposite is true with claims made coverage. You might have claims made coverage in 2022, but if you had no such policy in force in 2024, when you're sued, you would have no coverage. You have to have the coverage in place at the time the claim is asserted, not when the underlying incident occurred. As a result, claims made coverage tends to be less expensive, and I suspect most of you have it. There's nothing wrong with it. You don't have to change. But, for example, if you are going to retire, you need to get what's called a TAIL, which is extended coverage reporting, which means that even if you stop keeping the coverage in place, you will still be covered even if in a year, 2 or 3, let's say, a suit is filed against you. You may pay extra for that coverage. Or if you change from one carrier to another, you're going to have to be very cautious if you're going from a claims made policy to another, because you don't want to create a gap when you were not protected. All right, now further down in the declaration page, you can see here a reference to professional liability and licensing board defense. I cannot count the number of times a prospective client calls me. They say, I've just been sent a licensing board complaint. I say, do you have insurance? They say, yes. I say, excellent. Do you know how much coverage you have for the board matter? They say, yes, $1 million. And I say, no, you don't have that. Nobody has that. That would be if you're sued. And then in this case, this actually happened. They didn't have $1 million for a board matter. They only had $5,000. That's pathetic. It's inappropriate. I don't even know why some companies would offer that little amount by default. You have to know what you have, and you have to know to ask to maximize your coverage, in my opinion. But just to finish this off, you see here this coverage for the suit per incident and in the aggregate. What that means is that you have up to $1 million of coverage for settlement or verdict, up to that amount. If you were sued several times within a policy period, typically a year, you'd have up to $3 million of coverage, but not to exceed that. Now you see here the phrase reimbursement. What that means is that in the situation of board defense, typically, at least the way the policy is written, you engage the attorney, you pay the attorney, you submit the invoice to the carrier, and you get reimbursed. I will tell you, I have been successful most of the time in bypassing that, because I know cash flow can be challenging for many of you. And I've arranged it to be able to get paid directly by the carrier without you having to front that. That doesn't always happen, but it's something that I try to do. And it's very helpful. So let's talk a little bit more about this. I said $5,000 is totally inappropriate. It's way too small. Why? That may seem like a large sum. Well, it's expensive to hire a lawyer, and you don't want to have to pay out of pocket and be unreimbursed. And so if you only had $5,000 of coverage, as my client did, she had to pay me out of pocket for all of the fees above and beyond $5,000. Had she paid a little bit more in premiums, she would have had that paid by the insurance company. And so you can save huge amounts of money by an incrementally larger premium. And in my opinion, it's absolutely worth it. Now I'm going to make up some numbers just to illustrate this. Let's assume, for the sake of discussion, that to increase your board defense from 5,000 to 100,000 would increase your premium by $250 a year. It might not even be that much, but let's just assume that. You may say, you're being cavalier with my money. That's a lot of money. I can put it to use in all sorts of other ways. And I would say, yes. And if you don't do that, now you're going to have to pay me more than $250 an hour just for my time above and beyond 5,000. And I've had some cases where the fees are tens of thousands of dollars. So can you afford that? Which is easier, to shell out tens and thousands of dollars, or to pay a few hundred extra dollars and have that coverage? To me, it's pretty clear. So I think you should get at least 100,000, and it's not just for legal fees; it's also for expert witness fees, and that can be expensive as well. What it does not cover, so you know, is if a fine is imposed in connection with disciplinary action, the insurance is not going to cover that. It doesn't cover punitive damages. There are always exclusions in coverage. But you should look at what you have, read the coverage, and decide whether you want to stick with that insurance company. Not all policies are the same. So many of them will say, basically, if a board complaint's filed against you, you're covered. Some will say only if that board complaint relates to you providing professional services, which is a defined term, and it arises out of a professional incident, which is a defined term. You may say, well, why wouldn't that be sufficient? Usually it would, but I'll give you an example where it might not be. Admittedly, this is rare, but a number of years ago, I had a clinician, join a Facebook group, and she thought it was a support group for mental health professionals. So she learned early on that it wasn't, and she went on the site and messaged that she was interested in starting one, because this site was really for sort of dark humor and venting. The administrator of the site, who happened to be based in Wisconsin, was upset that this Rhode Island clinician, to his way of looking at it, was disturbing his group and trying to get involved in a way he thought was inappropriate. So he was very aggressive in responding. He got very aggressive in responding back. It escalated, and it went from private messaging to public messaging, and vulgarities were used. And then ultimately, the Wisconsin administrator filed a board complaint in Rhode Island against the Rhode Island clinician. And technically, it wouldn't have been covered because it didn't involve professional services. Fortunately, the carrier did agree to take this on, and we did get it dismissed. But it's an example of why you want to look at your policy. More importantly, to make sure you have enough coverage. And if you have no board complaint pending against you, there's probably no obstacle to you right now in the middle of a policy period contacting your agent or whoever you got the insurance through and saying, what's the most that you offer? Now, you may say, I work for a practice, an agency, a hospital, and they told me I'm covered. I don't need it. And I'll tell you why I still recommend that you get your own policy. I've already told you every policy has exclusions. And so it's possible that your employer's policy might exclude coverage for you, and then you'd have no coverage at all. In addition, it's possible that your employer's policy is inadequate. It may not have enough. I have an agency client right now. They have $25,000 of board defense coverage for their employees, and it's per person and in the aggregate. If they had 5 people in a policy period have board complaints, and it's a large agency, you wouldn't even have 25,000 of coverage. And that's just not enough. And it's very possible that your employer's policy does not actually provide board defense for you. I'm confident that if you're sued and your employer is sued, your employer's coverage will probably pick up your defense for the lawsuit. If it's just you that's sued, it may not happen that way. And again, the question is, how much coverage does your employer have? Even hospitals, and I have hospital clients that I deal with as well, sometimes are running tight on coverage because they can get sued a lot, and it can decrease the amount of available insurance to others during a policy period. So I think you should have your own coverage. Furthermore, I've had several times now an employee who was covered who engaged in unethical conduct. The employer filed the board complaint against the employee, terminated the employee, and the employer's insurance company took the position there was now no longer any coverage at all for the former employee. Right or wrong, that was their position. Now, the former employee had no coverage at all. So again, this is your professional livelihood at stake. I think it's important that you protect it as best you can. And getting adequate insurance certainly is one way of doing that. So there might be conflicts of interest between you and the employer that also are worth thinking about. In addition, there are other types of coverage for you to think about. HIPAA breach notification coverage, cyber liability coverage, coverage for subpoenas and testimony like depositions or in court. And they all have their own limits. You have to think these things through. For example, and this may have changed, but last I checked through NASW, many of you may be insured through Prefera insurance. They do offer excellent coverage for board defense. I believe you can get at least $100,000 if you ask for it. If you don't, you probably don't have it. But last I checked, they only offered $400 of coverage for a subpoena that required you to go to court or hearing to testify, which is terrible coverage. But as between the two, I would clearly prefer the larger board defense. There are some companies that might max out at only $35,000 for board defense, and I don't think that is sufficient. Again, most of the time it would be, but it's not always going to be that way. And I get paid to think about the contingencies. That's what defense lawyers do. So why would you need subpoena coverage? Let's say you have a client whose records are subpoenaed from your practice. And the first thing you should do is check with your client. Do they object? Do they consent? It's very possible, maybe even likely, they agree, because it may have to do with a lawsuit they filed and they think your records will help them in that case. But it's possible they may say no. If they do not consent, then you're ethically and legally obligated to take steps to try to not comply with the subpoena, which requires a motion to be filed in court to quash, Q-U-A-S-H, the subpoena, and or to obtain a protective order limiting disclosure. Even if that motion is denied, and it likely will be, it's still important to do that because then it results in a court order requiring you to comply with the subpoena, which your client did not want you to comply with. And now you're protected from a claim of breach of confidentiality, for example. So that's why you do it. And to the extent that this requires an attorney and legal expense, you want to have insurance coverage, adequate insurance coverage to do that. Similarly, if you unknowingly or perhaps even knowingly breach your client's confidentiality by disclosing their protected health information, then you're subjected to certain obligations, notifications to clients, to governmental authorities, state and federal. You probably want to engage a lawyer to do that. And there's insurance coverage for that purpose, but only if you have the coverage. I had a client some years ago who was seeing people in her office, but she had her records on her laptop. She was working on her laptop, got a pop-up notice that her computer was infected, that she should immediately notify Microsoft. She did. She spoke with a Microsoft representative. She downloaded, while speaking to that person, a malware program. She gave some financial information. They helped her upload it. She gave them remote access to the computer. And then she had her first client come in. So she left the computer, spoke with the client for an hour, came back. She sees somebody still on her computer. She realizes she has been scammed. It was not Microsoft who she spoke with, even though they identified themselves as Microsoft. Her records were not protected, they weren't encrypted, and therefore we had a HIPAA breach as to which there were obligations that were triggered under what's called the breach notification rule. Ironically, a week before this, she had the opportunity to obtain insurance. She didn't do it because most of her clients were college students and graduate students, and her records were extensive, including inactive as well as active clients. And most of those clients had moved out of state. She had to hire me. I had to look up laws in 25 jurisdictions. It was very expensive. And she could have had insurance to cover that expense. So these are examples of why you really need to be adequately insured. All right, now back to documentation. You're going to get so sick of me using that term. This is the very first thing that a plaintiff lawyer looks at to decide whether or not it's worth his or her effort to sue. Malpractice lawsuits are very time-consuming and expensive. Expert witnesses are among the largest of the expenses. Multiple experts often are retained in these matters. Plaintiff lawyers only want to take on cases that they think they are likely to win, and if they win, they're likely to get a large verdict. So they're going to look at your records. And the question you need to ask yourself is whether that lawyer looking at your records is likely to conclude that they have a case or not. Will they decide, oh, I see the issue they addressed, they documented beautifully, I can see exactly what their diagnosis and treatment plan was. They had consultation that was documented, they acted reasonably, and yes, it's true that my client ultimately died by suicide, but I don't think I'm likely to win based on this documentation. Or is the lawyer going to say, I can drive a truck through these records. There's not a single thing documented about a suicide risk assessment, not a single thing. Or it says client was depressed and client was at least passively suicidal, or maybe it just said had suicidal thoughts, And there's no documentation as to why the clinician decided in the face of that to proceed with treatment and not intervene in some way. That's going to result in a lawsuit. So will a jury looking at your records or a board likely find what you wrote to be helpful to you or harmful? And just like you're looking now on a screen with a PowerPoint, in court or in a conference room, your records can be projected onto a large screen. And through the use of software, we can enlarge the type, we can highlight terms, we can point big arrows to different parts of the chart. And so the plaintiff lawyer cherry picks records and decides how they can weave a narrative to support their claim. And they're going to show these records in that manner. Will your defense lawyer be able to say, oh, but look at this next page, or look further down the page? They didn't show you this. Can the lawyer do that? Or are they going to have to work with a huge disadvantage because of the way you failed to document? It goes to credibility, actually. And the other thing that you should know about plaintiff lawyers is that they like to argue that if it wasn't documented, it didn't happen. So if you didn't document a suicide risk assessment, they're likely to argue you never did one. That doesn't mean you didn't do it. You might have done it, but failed to document it, perhaps deliberately, perhaps inadvertently, but that's how they will handle this. And you have to say to yourself, how is a juror or a board member going to react to the absence of documentation? So this is the reality. Documentation is really, really important. There's all sorts of reasons that it's required. By the way, I am continuing to be shocked. It doesn't happen a lot, but I sometimes encounter clinicians who have private pay clients, and they somehow think that because they are not accepting commercial insurance, they're being paid directly, that they don't have to document either at all or to the same standard. That's not true. The standard of care, which I'll talk about soon, requires all clinicians to document consistent with the standard of care. It's not waived by not having insurance. Insurance is irrelevant. The form of payment is irrelevant. You could be seeing somebody for free, for Blue Cross rates, or private pay rates. It doesn't matter. You still need to document. Now, it's true that if you are using a third-party payer, it also has documentation requirements that you have to adhere to. They might be very detailed and specific about it, and it behooves you to find out what those requirements are. But you're not relieved of responsibility to document appropriately just because it's a private pay scenario. This very simple sentence, which is from the Joint Commission, and those of you who work at, for example, a hospital, know the accreditation process, basically captures my point that you need to justify the diagnosis and warrant the treatment in the manner in which you document. For those of you who still use hard copy records, there's nothing wrong with that. There's nothing wrong with handwritten records. And some people still do that. That's not illegal. It's not prohibited. But if you can't write legibly, it's going to be problematic. So, for example, I've had situations where clinicians are asked to read their progress notes, and when they attempt to do that, they get stuck because they can't read some words in their chart. It's very embarrassing. It's not a good look. By the same token, your typed notes in an electronic record might be very easy to read because it's typed, but it may be filled with typographical errors or informal abbreviations. And in my judgment, that detracts from your credibility. It makes you look less professional. I worry about how third parties may perceive that. So there's a lot of aspects to the consequences of how you document. And I've already touched on earlier before the break about there's no one way to document, but I hope you're beginning to see why a more detailed note frequently will be the way to go to protect you, which might either prevent a suit or help you defend a suit, either way. Now, there are times when, for example, you might be needing to be circumspect. So now, sort of a hot button topic that's come up, some of you might work in states where they have very strict abortion laws, that they virtually prohibit them, or they prohibit them very early in the pregnancy. And in some cases, they might even threaten providers who in some way assist somebody in obtaining an abortion. So the federal government's in the process now of what we call rulemaking to try to make this clear, but the federal government's position is that you ought to be circumspect about how you document in these situations. You would not want to document, for example, in detail, client told me she had an abortion, or client told me next week she's going to the neighboring state to get an abortion. You would be much more vague and say something like discuss healthcare issues or decision making, or maybe even more vague than that. But those again are the exceptions to the general situation where you need to be able to support your decision making, and it has to match. So, for example, some years ago, I had a social worker client. She saw a police officer. He had both symptoms of depression and sort of anger. At one point, he was having job issues, and he said, "You know, there are times when I'm so angry at Sergeant Jones, I could just put a bullet in his head." He talked about being depressed, but he also talked about forward-thinking things. Now, the clinician made a judgment, a clinical judgment, that he was not likely to kill himself or harm Sergeant Jones. But she had concerns. She started seeing him more frequently, and she showed me some of her notes to review. One of her notes had a quote in it. Essentially, sometimes I'm so angry at Sergeant Jones, I could just put a bullet in his head, close quote. That would be a great quote to put in there if you decide that because you're so concerned that he's likely to act out on his homicidal ideation, that you need to notify Sergeant Jones or third parties. That would be a great quote to put in there. It's a lousy quote to put in there if, to the contrary, you've decided there's a very low risk of that happening. There's no point in quoting him in that context. Instead, if the quote is, he told me he would never do anything because he wouldn't want to hurt his family. He was planning to purchase a boat next month. Anything that's objective and that is perhaps quote worthy, that is consistent with your clinical judgment, makes perfect sense to include. But the mismatch is really problematic. And so that's another point for you to think about. Now, you should assume that everything you write at some point will be read by, if not your client, some third party. Now, is that likely to happen? Probably not, but that's how you should roll, in my judgment. I'm a defense lawyer. I'm thinking ahead at what may happen. And so how does that affect you? What I urge you not to do is to suddenly say, well, now I'll be as vague as possible because I don't want to upset my client, or I don't want anyone to read my records and see what's going on. That's going to increase what we lawyers say is your exposure to risk. So you try to avoid inflammatory language, be as objective as possible, but don't let that chill you into being reluctant to write the important points, because that's not going to help you, and it ultimately may not help your client either. Now, this is an example from an actual electronic medical record, and I offer this just to help establish my point. So this is the very first entry and the very first record for this person. And so let's look at it. Client discussed increase of reported issues described above. There's literally nothing above. So that made no sense. There's increased ability to identify triggers to symptoms, decreased ability to identify triggers to symptoms. How do we reconcile that? Clearly, this particular EMR system, which was designed to save time, has drop-down menus, and you could click on a bunch of options and then it would populate this chart, and you might think that looks great, but it was so generic, it wasn't helpful whatsoever. In fact, it created more issues than not. So for example, we've got the client reporting all of these issues, and we have these references to progress. We have all of these interventions that are used. Now, keep in mind, this is one session. So the clinician is saying all of this happened during the one session. Is that credible? And if, as was the case here, every single entry looked essentially the same, is that credible? And if not, if it's not credible as to this point, does it detract from your credibility on the really important points? Most importantly, there was a place where you could free type what actually was discussed. None of that was typed. So we have these generic comments, and literally you cannot tell at all what is going on in this case. So here's what happened. A mother brought her child in for therapy. It's a contested divorce situation. Those are always red flag situations. Your documentation should be great for all charts, but especially important for red flag situations. There's many different red flags. It could be clients who stop paying their bills, who are complaining constantly, who have sued many people, who have seen 3 or 4 therapists in the last year and a half before seeing you, who have borderline personality features or have significant diagnoses, who have custody situations, who are not following your advice. They stop paying your bills. There's any number of situations where you can foresee there's possibly trouble ahead. Suicidal ideation and homicidal ideation, certainly as well. So in this case, the mother the mother brings in the child, clinician sees the child. After a few sessions, the father calls up the clinician on the phone. The first thing the father says to the clinician is, quote, "Just so you know, I'm an asshole," close quote. That's what he said. Now, to a defense lawyer, and I hope to somebody like you, that sends off a 5-alarm fire alarm situation. That should have been reduced to writing and quoted, in my opinion, right away. Why? Because this guy is trouble. He's telling you that. And you need contemporaneous documentation to best protect you. So that didn't happen. Later on, predictably, the father filed a board complaint against the clinician. And I prepared a response on behalf of my client. When I do that, I have very detailed, lengthy responses, single space, many pages. I just did one that was, I think, 9 pages long, thoroughly analyzing the situation. And I made certain that on the first page of that response, it quoted what the father said. Why? Because I think it puts the father in a very negative light and changes the way a board might think about this from the outset. We got this dismissed. It would have been easier to dismiss it had it been in the records. It was not. Other things that were not documented. The minor said that she had been called mentally ill by the father's girlfriend. Both the father and the girlfriend were making disparaging comments about the mother. On the other side of the coin, the minor did say she wanted to, quote, be a child and visit with dad, close quote. Now, as it turned out, this clinician wrote a letter, 2 of them, I think, to the family court, where some of this was included, and that's how I knew about it, also just by speaking to the clinician. But the comment from the father wasn't. And again, it should have been in my judgment. So there's, as I said, ways documentation can affect the outcomes of cases. For those of you who work at hospitals or agencies, possibly larger practices, there may well be policies that relate specifically to documentation. If you fail to adhere to those policies, that can be held against you. The plaintiff attorney will argue that's evidence of negligence and the failure to adhere to these policies. So please keep those in mind. There might be federal or state statutes in your jurisdiction which speak to documentation. One thing, if you haven't done this already, I'll give you some homework. I know that thrills you, but it's important. Let's say you're a social worker in California. Google or use another search engine. California social worker regulations, California social worker statute, or depending on what's applicable, Minnesota mental health counselor regulation statute, psychologist, Massachusetts regulation. You need to know what's required of you and what's prohibited for you to do. If you don't read the statute and regulation that governs your field, you are shooting in the blind. You don't want to be doing that. By the way, in some of your states, it's possible that you are in what you might call a combined board. So for example, both Massachusetts and Rhode Island combined the board for mental health counselors and marriage and family therapists for some reason, but have separate ones for psychologists and social workers. It varies, but look it up. What you'll also likely find is that they refer to the code of ethics that applies. Now, if you're a psychologist or a social worker, there's only one, so that's not a big surprise. But for some reason, mental health counselors are potentially subject to 3 different codes of ethics. there's the American Counseling Association, there's the National Board of Certified Counselors, and there's another one, a Mental Health Counselors Association Code of Ethics. It's possible that in your state, they choose one, possibly even two of those codes. It's very useful for you to know which code of ethics governs your conduct, and read your code of ethics. By the way, you might say to yourself, well, we did that in grad school. Terrific. Guess what? They get amended. You have to stay current. The NASW Code of Ethics has been amended many times in the last several years and is much longer than it used to be. So you need to know what that says. Now, as you look at these statutes and regulations, you will see that some of them, but possibly many of them do not, tell you what type of documentation is required. And so that's why in a few slides, I show you what Massachusetts requires for documentation of social workers. And if you are a psychologist in Wyoming and they don't have any regulation about documentation, my argument would be if you follow the social worker regulation in Massachusetts, which describes documentation in detail, you're going to be well protected, by example. It also will tell you what conduct is going to subject you to disciplinary action. So you need to know what that says. So look up these statutes, look up the regulations, read the codes of ethics, and go online and look at the Department of Health or whatever it's called in your state or your board website and see if there are other documents that relate to your practice. For example, in Massachusetts, they have advisories, basically guidelines that can be quite useful in very specific situations, such as dealing with consent of minors, treatment of minors in the context of a divorce or custody dispute. Very specific. And if you hadn't looked that up, you'd have no reason to know about it. So keep that in mind. I've already mentioned third-party payer manuals. There's also professional organization guidelines, and it's not just about documentation, but it can include that. There is one for psychologists for record-keeping guidelines, for example, but NASW has standards that deal with technology. You should stay current and look at these things as well. Now, as I mentioned before, I was going to talk about standard of care. This is something that applies across the country and is particularly important in the context of a lawsuit. So let me just take a step back and tell you a little bit more about malpractice lawsuits. These are negligence claims. It's just a fancy label for a type of negligence lawsuit. And in any negligence case, a plaintiff lawyer who has the burden of proof, it's the plaintiff that has the burden of proof, in a civil case by what we call a fair preponderance of the evidence to prove four things. A duty is owed, there was a breach of the duty, it caused harm, and what the harm was. In the context of malpractice, the breach of the duty involves this concept of standard of care. To prove the duty is quite easy because all of you owe a duty as a matter of law when you treat your clients. So the breach has to do with whether you met or violated the standard of care. The language used state to state varies, and even within the same state, different language might be used. There's more than one way of describing it in Rhode Island. But all of the states have the same general concept of reasonableness. The issue is simply, what should a reasonable person in the shoes of the defendant, the person sued, that's potentially you, what should they have done at the time of the alleged incident? So it's a so-called objective standard. It's not what the person thought subjectively was a good or bad idea. It's what an objective person, a reasonable person, should have done, somebody who works in that same field at that time. And you need to prove that, and you need to prove that the breach caused harm. In Rhode Island, we use the phrase, what should a reasonably competent practitioner have done? Massachusetts says what the average qualified practitioner should have done. I don't like that language because by definition, average presumes half of the people are above average, half below, and that's not consistent with the understanding of standard of care. Really, it is a way of establishing a floor, a minimally acceptable level of professional competence that's required of you in treating your clients. And the plaintiff has to prove that you failed to meet it, that your defense attorney is going to try to prove that you satisfied that standard of care. So what is it? There's many sources. Ultimately, it sort of is whatever an expert witness says that the jury believes. That's ultimately what it's going to come down to. But it's based on many sources. It can be, by the way, the statutes and regulations that I talked about. It can be written, published appellate decisions, intermediate or Supreme Courts, or what we call courts of last resort. Rick mentioned the Tarasoff case, which used to be the case law that was part of the standard of care in a duty to protect scenario. Actually, now in California itself, it's governed by statute. That is how to address the duty to protect. Some states have incorporated the Tarasoff decision or some version of it. Some have not addressed it at all. Some have statutes. You need to know what the law is in your jurisdiction. That's part of it, the case law. Also, the code of ethics, which, as I said, is embedded often into the statutes and regulations. So you might think of a code of ethics as being, this is sort of generally a wish list of what you should do. But when it's embedded into a statute or regulation, and the failure to adhere to it can expose you to disciplinary conduct, essentially now it's legally required. It's not just, it'd be nice if you do it. If there are policies, protocols, guidelines, that's all part of the standard of care. Professional literature is another source. And as I said, these things get amended. So that's important to keep in mind. But let's say in my original scenario, we have a suicide in 2022. You're sued in 2024. It might not come to trial until 2027 or 2028. The issue is whether you met the standard of care in 2022, not 2028. The standard of care may have changed in the interim. That's legally irrelevant. The question is, was the standard of care met at the time that you provided the treatment? By the way, so in my hypothetical, we know that your client died by suicide. That doesn't mean automatically that you were negligent. That's not the final step. We, in fact, will have a jury told that hindsight is not part of their deliberations. The mere fact that somebody was injured or harmed doesn't mean that there was any negligence at all. Instead, the jury has to decide, did the defendant act reasonably at the time? That's why it's so important to look at the documentation in the chart and see if that helps to support the case. So it's a prospective standard. Hindsight is not part of it. So there will be a battle of the experts. The plaintiff will have one or more experts who will say that the defendant breached the standard of care. The defendant will have one or more experts to say the defendant met the standard of care. And the jury will have to decide. In some cases, it's a what we call a bench trial. The judge alone decides, but that's rare. And documentation is relevant to this concept of standard of care. Unlike a lawsuit, in board complaints, standard of care and causation are not necessarily relevant. They can be, but they're not necessarily. I'll give you an example. Let's say that a medical provider gives the wrong medication or the wrong dose of the medication to a client, but the client is not harmed. Maybe the error was caught before the medication was dispensed, or for whatever reason, they weren't harmed. There might not be a basis for a lawsuit because there's no harm. But even if there was no harm, you still could very well be disciplined for that misconduct in prescribing the wrong med or the wrong dose of that medication. With board matters, there's all sorts of grounds for disciplinary action, and some of them have nothing to do with your actual practice, and so standard of care clearly wouldn't be part of it. For example, if you're convicted of certain crimes unrelated to your practice, you could be disciplined, not related to standard of care. You might have an impairment that doesn't necessarily cause harm to your client, but nonetheless, you might be disciplined for it. You might be disciplined because you misrepresented your credentials or your background. You could be disciplined because you were disciplined in another state. There's lots of grounds, and you need to know in your state what applies. And it's not the same for every professional. So now we're going to talk about board complaints. Please, 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 never, ever try to answer a board complaint on your own, especially when you have insurance. It's just not a wise decision for many reasons. First of all, no doubt you're going to be stressed at that time. You might be emotional. You might be angry. You might think this is frivolous. That might even be the reason you try to fire off a response on your own. But there are two main problems. One is you don't know what to say, and two, you don't know what not to say. You're not trained to do that, but lawyers who have experience in this area of practice are. Use them, especially if you've paid insurance premiums. Why would you not want to use them? When you receive notice of a board complaint, they will not tell you typically, contact your insurance carrier. They will not say, retain a lawyer. But those are both things that you should do immediately because there's deadlines. Now, let's say you got a board complaint, and because it was delayed in the mail, you receive it and you see 2 days later a response is due. Don't panic. Try to get a lawyer, and if you can't, in time, you could ask for an extension explaining you just received it. but please don't talk about the merits of the complaint. You could actually expand the scope of the complaint simply by doing that. You might make an admission that is inappropriate. Boards are not limited to the four corners, the four squares of the complaint. They can amend it or expand it. So if, for example, they see your documentation, they might say, oh, we see the complaint was filed on grounds A and B. Now we're going to add C, D, and E because we can see all these new boundary violations. So you need to get a lawyer. Now, I mentioned earlier about insurance. When you're sued, insurance companies typically reserve the right to select an attorney for you from a pre-approved panel of defense counsel. You might, if you know somebody who's on that panel, say, I would like to have so-and-so represent me, and they may honor that request. But if the attorney's not on that panel, they probably won't allow you to be represented by somebody who's not. Conversely, in a board matter, typically insurance companies will agree for you to select your own attorney. And you need to tell them, and you should make sure that it is approved, and it has to be done quickly. Insurance companies can take time to make this decision. So sometimes it uses up quite a bit of the time available within which the response is due. But again, extensions can be obtained. I had a case recently where the employer thought they might have coverage for the employee. It turned out they didn't, but it took time to figure that out. The employee then said they had their own policy. They didn't tell me that they had just purchased it, and it wasn't in place at the time of the incident. Took some time to work that through, but it turned out that the employee did not have insurance to cover the claim. Fortunately, the employer voluntarily agreed to pay me to represent this employee, which was quite generous. The process varies state by state. I'm just going to give you some general understanding of how this works, both in terms of procedure and consequence. So procedurally, you get a complaint. It's going to require a response. It likely also requires copies of the records. It may require copies of your continuing education certificates. Please don't throw those out. Make sure you always have them available. They're not going to go back indefinitely in time, but it's good to keep them on record in case you sort of get audited. And then, in my experience, frequently the cases are dismissed just on the basis of the lengthy response. I'll be citing regulations or statutes or codes of ethics, referring to the records, referring to the background of the clinician, and so forth. But they might want to meet with you. They might want to have a contested hearing. You should never go to these things unrepresented. Attorneys can help prepare you to testify and to respond to questions, and they're trained to do that. You should take advantage of it. Ultimately, it's going to either be essentially dismissed or there's going to be some kind of disciplinary action. Sometimes based on the allegations, there's what we call a consent agreement or a consent order. In other words, it's really not disputed that there was unethical conduct. The question is, what can be done to minimize the damage? So another value that your lawyer brings to the table is negotiating a favorable result, even when some type of discipline is inevitable. It could be for any number of reasons. It could be a boundary violation, failure to document well. That alone can be the grounds for disciplinary action. Unfortunately, I've had several clinician clients who had sexual relationships with their respective clients. I'm not going to go to a contested hearing in that situation. I could never win. The most that I can do to help my client is to probably minimize the length of the suspension of the license because of that relationship, and to make the pathway to regaining licensure as seamless as possible. Also, experienced attorneys know the attorneys that represent the respective boards. They know the board managers. They might know board members. And so they have a rapport with them. They have a professional credibility that can help you. They know when I represent somebody that if I'm pushing hard, it's because I feel pretty confident in my position. They know too that when I'm forced to, I'm going to be talking about a consent order as opposed to going to a hearing. So in Rhode Island, for example, if it's dismissed, they might say, we issue a finding of no unprofessional conduct, or we're administratively closing the file because we failed to find, after investigation, any reasonable basis to substantiate the claim. That's a dismissal. That's a home run. The spectrum of disciplinary action can range from censure, reprimand, to probation, to suspension, to absolute revocation. And there are sort of hybrids in between. You need to understand that if disciplinary action is actually effectuated, it's publicly known. And so if you go to your respective boards or departments of health and look up individuals, you can find out if they've been disciplined. And for those who have, you can usually find an icon, a PDF, and you can open it up and it'll state with a fair degree of detail, depending on the state, what occurred factually and the grounds for disciplining and what the actual punishment is. So that's known, and the National Practitioner Data Bank is informed as well. So you can't hide these results. When you renew your license, when you apply for a license in another state, when you renew your insurance, you will be asked about your past history of being disciplined. And if you have, you certainly can't be untruthful, because that will make things much worse. And there's this record in the National Practitioner Data Bank. Sometimes I've had clients who have licensure in at least 2 states, typically bordering states. So they might say to me, I'll tell you what, I'll just make this go away. I'll surrender my license in state A, and I'll just work in state B. It doesn't work that way. Surrendering your license during a pending investigation is a red flag. It will be reported to the National Practitioner Data Bank. The other state will find out about it. So you can't use that sort of ostrich approach and just hide. That's not going to work. The types of sanctions that may occur varies as well. And this link gives you a good overview. But for example, in some cases, not often, there might be a requirement of ethics supervision. And Rick has done that a number of times. There might actually be a requirement of clinical supervision. Both of those expenses have to be paid by the clinician. And sometimes the insurance will pick that up. So you need to have enough coverage. Often there's continuing ed requirements. If it's a boundary violation case, you can expect that you'll be obligated to take more courses in those relevant issues. So that's often something you see. Rarely, but sometimes they'll require the clinician to be assessed in a forensic psychiatric examination. Sometimes even a psychological one where they administer a battery of tests, where they're really looking to determine fitness of duty to practice. That can occur as well, and those assessments are quite expensive. If somebody has a substance abuse problem, they might require you to go to an out-of-state program, which can be quite expensive. Please also understand that while for lawsuits in every state, there are statutes of limitation, usually about 3 years for a malpractice case. In most states, there's no such statute of limitations for board matters. And so California is an exception. There's probably others. You might have a board complaint filed against you 4, 5, or more years after the fact, and it's not going to be dismissed because it's too late. This is also important because people frequently ask, how long should I keep my records? And there's unfortunately no single good answer. It depends on so many factors. But one of the things that I would tell you is that don't go by just the statute of limitations to make that assessment. Because if you say, I'm going to get rid of my records 3 years after I last saw somebody, you've got a lot of problems with that. What happens if you have a board complaint filed against you just after that period expired? It's hard to defend yourself without a chart. In addition, even in lawsuits, there's something called the discovery rule, which can extend the statute of limitations. So the classic example would be, let's say a surgeon inadvertently leaves a foreign body inside you during surgery, and you have no reason to know about it because you have no symptoms. But say years later, you have an x-ray and somebody says, you might want to take a look at this. And clear as day, you can see forceps left right inside you. That would trigger the start of the statute of limitations in that case, because through the exercise of reasonable diligence, you had no reason to know before that there was a basis to assert a claim. So the statute of limitations can be extended. In the context of behavioral health, it's harder to apply that, but perhaps with repressed memory, that might be a situation. Actually, I have a lawsuit I'm defending now where the plaintiff says that they had dissociative identity disorder and that they were effectively disabled until years later, and that disability essentially excused them from filing the suit within the statutory limitation period. So it can come up. Again, these are various types of board complaints. We're not going to go through them all, but you can see there's all different kinds of grounds. This is that regulation I mentioned earlier with regard to Massachusetts social workers. And I just want to highlight a few things. I usually find clients have good charts at the beginning, excellent intake records, often a treatment plan. And then with some frequency, I find progress notes that don't have any diagnosis, excuse me, or the diagnosis has subsequently changed, but it's not documented. And so this regulation makes clear that, among other things, you not only need to have the assessment or diagnosis documented, but changes in it. Not just a treatment plan, but changes in the treatment plan. And this is something that's important. It says documentation that the client was informed of his or her confidentiality rights. So that needs to actually be documented. Now, if you, again, are in a state where your regulation or statute is silent about these things, my point is that if you followed this regulation, you'd be well suited. By the way, my position with respect to informed consent is what you might think of as a trifecta. First, informed consent, first and foremost, is always oral. It's not a consent form. It's you discussing with your client, let's say, the exceptions to confidentiality. That has to be done, and in my opinion, it should be done at the very first session. It's not a replacement for that to simply give them a form to sign. But that's part of it. So number one, tell your client about the informed consent. Second, document that you did that. That can be very brief. And third, ideally, you have an informed consent form that is signed by your client, and above their signature, it says, I have read, understood, and agreed to the terms in this document, and have had an opportunity to ask questions. That's the trifecta that helps you. Does it prevent somebody from asserting breach of confidentiality down the line? No. Will it help you greatly? Yes. If you fail to do any of those, and they argue you failed to disclose the exceptions to confidentiality, you can still testify that that was part of your routine practice, and that on the first session, you always tell all your clients the same thing, including exceptions to confidentiality, such as threats of harm to self or others, or abuse involving children, elders, disabled people, what have you. But it loses a lot of its force if there's no corroboration, contemporaneous corroboration. And that's how you protect yourself. So before I go further, Rick, I don't know whether there's any particular questions that you want to go through now.
Well, my current tally is we have about 412 outstanding questions. Well, not exactly, but I've been answering lots of them rather furiously, but it's hard to keep up, frankly. So let me just pick out several that I think would have broad applicability and get your thoughts on these. So one of our participants asks, well, I'm going to paraphrase. I don't bill anybody electronically. Does HIPAA apply to me?
So probably not. It's not just about billing, but it's about engaging in certain transactions. And if we had time, I could pull up the HIPAA regulation. But generally speaking, there's got to be some type of transaction that triggers the applicability of HIPAA. HIPAA doesn't apply automatically to all providers. Let's assume you have no electronic footprint whatsoever, not just the records, but your billing, what across the board. Technically, HIPAA wouldn't apply. Does that make it irrelevant? No, because it really sets forth some central principles about confidentiality that makes sense to apply, generally speaking, but you wouldn't be required to adhere to it.
I would add to that that you also need to be cognizant of statutes and regulations in your state law. regarding confidentiality. So even if technically you don't fall under HIPAA, you would still fall under some very specific confidentiality guidelines, including confidentiality exceptions that are embedded in two places typically: state statutes, in other words, those are laws passed by your legislature, and also regulations that's usually in, for example, licensing board regulations, which often have a section on confidentiality. Right, Bob? They need to also consider the state law.
Absolutely. And sometimes beyond that, some states like Rhode Island has a very comprehensive statute that's sort of the central warehouse you would go to analyze confidentiality of healthcare records. Massachusetts doesn't have that, but both of them have scattered around various statutes to address discrete situations, like the extent to which consent's required of a minor involved with treatment of a sexually transmitted disease, or engaged in substance use treatment, or dealing with HIV situations. There's many different single statutes that one would need to be aware of, and it does vary greatly by state. And for those, and there were some involved in substance use disorder treatment, 42 CFR Part 2, CFR's Code of Federal Regulations, has an extensive regulation dealing with confidentiality of substance use disorder patient treatment records.
So Bob just mentioned that some states have very comprehensive confidentiality guidelines in a statute. So what I just put up on the screen is Rhode Island's. Rhode Island, I think, for example, has a very good statute, Title V, Chapter 37.3, which includes lots of guidance regarding any confidential communication that involves a healthcare or behavioral health care professional. But not every state consolidates this in the same way. Okay, so we have a number of participants who provide services to minors, and a number of people have posted questions about the extent to which parents or legal guardians have a right to see the clinical records pertaining to the minor clients. So what I typically say is that if you are providing services to minors, I would write every single note, or type every note as if the parent will read those notes. Because in my experience, generally speaking, there are some exceptions. The courts will recognize parents' right to examine the clinical records pertaining to their minor children. I have encountered some exceptions. For example, there's a case in New Hampshire, which I referred to very briefly this morning, called Berg versus Berg. The New Hampshire Supreme Court basically said that parents do generally have a right to see the records of their minor children, unless, and there are some narrow exceptions. For example, if the parent's access to that record might put the child in harm's way because of information that's in that record, or if the evidence shows that one parent is trying to weaponize the record to use against the other parent in, let's say, a child custody dispute. In other words, the parent's motive is not to just look at the record because they care about the child, but to weaponize the record. But generally speaking, in my experience, courts have recognized parents' right to access those records, and I would record notes accordingly. Bob, what do you think?
So generally, this is very contingent on state law. So you have to know what the law is in your jurisdiction. The default under HIPAA generally is that parents have a right of access to protected health information. But there's a significant exception, which I'll be discussing, involving a very highly defined term called psychotherapy notes. That is to say that under HIPAA, patients, including parents, have a right of access to their records, their PHI, but they do not have an automatic right of access to psychotherapy notes. And That doesn't stop the clinician in his or her discretion from deciding it's okay to share that, and they do often do that. They can, but there's no absolute right to do that. The other thing I mentioned much earlier today, I'm a big fan of managing expectations at the outset. And I'll explain what I mean by that, but let me just preface this by saying, I recognize that some of you are solo practitioners and calling your own shots, and many of you are not. And I might be, during the course of today, saying things that conflict with the practice in your position. And I know that creates cognitive dissonance. That's not my intention. If what I said today makes sense to you, and it's not the way you do it, you might want to have a discussion with your supervisor and see if things might be done differently. But I recognize that people might have different ways of handling this. So even in states where the default might be that parents have a right of access or to talk to you about treatment, if a therapist said, look, I'm happy to treat your teenage child, but the only way I'm willing to do that is if essentially you waive your right of access to it or to talk to me about it, unless there are limited exceptions that occur, such as your child threatens to harm him or herself or others, or there's a question of abuse and a few other examples, I'm not going to share that with you. And if there's proper informed consent and it's signed off, and I have a link, and you could just look it up under, let's say, you go to APA informed consent with minors, you'll find an extensive form that describes situations where they're not going to disclose information. For example, the minor might disclose that she smoked a cigarette, and the therapist will say, it's even in writing, your child tells me that they smoked or had a drink once, I'm not going to tell you that. But if they tell me that they drank alcohol and then drove, or they got in a car as a passenger and their driver was drunk, I am going to tell you that. Now, that may not work in every state. I'm not expressing a legal opinion about it, but I think it's done often, and I think it's appropriate, and I think it advances therapy for minors.
So speaking of minors, a couple things, maybe we can squeeze this in before we break for the lunch hour. And I realize for some of you, this is like the dinner hour. Or I think we have somebody from Europe, at least one person from Europe. So it's like going to be really late. So what about providing services to minors without notification of parents? Now, obviously, if you need their insurance card, the parents are likely to find out. But a lot of agencies have federal grants or state grants or contracts to provide services to minors, and you don't need the insurance card. And so then the question is, are you able to provide services to a minor when the minor says, I don't want you to tell my parents I'm getting this counseling? And I alluded to that in one of the brief examples at the start of the day. And here too, state laws vary significantly. And you may need to consult with a lawyer about the extent to which services may be provided to a minor without notification or consent of the parents. But I'll give you one quick example. So Bob referred to, actually I did as well, Title 42 CFR Part 2, which you see on the screen here. This is the very strict federal law governing the confidentiality of substance use disorder patient records. And if you scroll down, this is like a 30-page document if you print the thing out. And if you scroll down to section 2.14, they use the term patient, not client. It says, with regard to substance use disorder treatment, if a minor patient acting alone has the legal capacity under the applicable state law to apply for and obtain substance use disorder treatment, any written consent for disclosure authorized under subpart C of this law may be given only by the minor patient. Now, I have been in cases where the clinician says to me, oh, this clearly says that the minor controls the consent. And I say, well, no, you've got to read this very carefully. It says under the applicable state law. So then the question is, what's the state law? And the state laws vary tremendously with regard to provision of services to minors for substance use related issues without consent of the parents. So, for example, I'm going to do this very quickly, but this to me is an educational moment here to illustrate how complicated ethical decision making is, risk management, because if you provide services without notification of parents, the parents might go after you. If you refuse to provide those services, but you were permitted to, you may have just ruptured the clinical relationship. So there can be problems in both directions. So as an illustration, Bob and I are in Rhode Island. So here are the Rhode Island laws. The federal law that I just showed you said you've got to consider the applicable state law. That's the language, applicable state law. So if I were consulting on this case in Rhode Island, I would go down to Title 14, which has to do with delinquent and dependent children, child welfare stuff. I'd go down to this section, treatment of juveniles for chemical dependency. And then I would go to this section that says, basically, in all treatment of a child for substance abuse or chemical dependency, the parents have to be involved and the parental consent is required. But then it says, except as otherwise provided in the next section. And if you go to the next section, in Rhode Island, practitioners are permitted to use their clinical judgment about whether the contact with the parents, look at this language, would not be helpful or would be deleterious to the child who's voluntarily seeking treatment. You have to make a good faith effort to get the kid to consent to involve the parents. But it's a clinical judgment. That's the applicable state law in Rhode Island. But an 8-minute drive from where Bob and I are sitting right now, you've got to deal with Massachusetts law. And Massachusetts law on this same issue is completely different. In Massachusetts, the minor must be 12 years of age or older. Rhode Island says nothing about age. In Massachusetts, 2 physicians have to sign off that the kid needs this help. Rhode Island law doesn't say anything about that. And if you go just to our west in Connecticut, the law is completely different. So this is a good example of why you need consultation. Sometimes you've got to think these things through carefully. You have to consider federal law, you have to consider applicable state law and relevant ethical standards. Bob?
I agree with everything you just said.
Some of you perhaps are just banging your head against the wall right now thinking, oh my goodness, this is complicated. Well, yes, it is. And we're trying to teach a process here. We could spend all day teaching facts about this statute, that regulation, but those facts could change tomorrow. Especially what we're teaching today is a way of thinking. Bob, can we take one more before we break?
Sure.
Okay, so this is one where there's a lot of interest. Both of us have mentioned that we need to be careful about when we're vague in case notes, when we're explicit or detailed in case notes, and several of you have asked. So how do you do this? I'll give you my quick answer. Maybe we can explore this later after lunch. I'll give you my quick answer. In my opinion, there's no one-stop shopping here. I think it depends on the facts. I think it depends on the circumstances. If there is a health and safety risk, I favor more detailed documentation. Suicidal ideation, suicidal gesturing, possible threats to a third party. I think those circumstances call for more detailed notes. On the other hand, if a client is disclosing to me that he is struggling with sexual orientation or gender expression issues, and he's involved in a child custody dispute, I'm going to be vague in my case note. If a client reports to me that he committed a crime 7 years ago, had never been caught, charged, convicted, sentenced, I'm assuming my records may be accessed by third parties. I am not putting in my notes that the client disclosed that he committed that crime. I'm putting in my notes something like client disclosed details about a past traumatic event, shared feelings of guilt and remorse. And then, then whatever we did with all that. Sometimes vagueness is a virtue, given who might have access to the record. I think sometimes vagueness is a disaster. And I argue, if you're not quite sure whether to be vague or detailed, I favor getting consultation before you write that note. Unless it's an emergency, get some consultation. How do you think I should write this? And then write the note. Bob?
I agree with that. And I would say that in the context of when more detailed notes are appropriate, I wouldn't confine it to sort of the health and safety risk. I recognize you offered that as an example. Mm-hmm. I spoke earlier about the so-called red flags. I'm thinking defensively on behalf of you all. And when you have scenarios where you recognize you could easily face a suit or a board complaint because of those red flags, either because the client's threatening, there's a custody battle, they have a propensity to be litigious or dissatisfied, they're threatening. I went through this before. You certainly want to be more detailed and more prone to quote the client, I think, in those situations. So it does vary on the context.
Yeah. And I'll make one more comment. I know we need to break for whatever you want to call this meal that you're about to have. Just one quick comment. One of you posted in the Q&A, well, what about if a client is reporting suspected abuse or neglect? Should you be vague or detailed? And you may have to call protective services, mandated reporting. My opinion, Bob, I'm curious to know yours. I would say in that situation, I tend to favor more detail because there's always the possibility that the alleged perpetrator, if you report it, they're going to go after you. They're going to file a complaint for wrongful reporting. They could file a defamation of character complaint. And I think having detailed notes is a very important way for you to protect yourself if somebody questions your judgment. Bob?
I absolutely agree with that. In fact, it's likely that the disgruntled parent or caretaker is going to do that. So thinking that through, what will your chart say to help people understand, why did you do this? This is an extraordinary event. Why did you do it?
Exactly. Okay. We've run over 2 minutes. Spencer, is there anything you want to say before we take this break, or simply when we return? All right. So we'll assume Spencer doesn't need to say anything right now. We ran over by 2 minutes. We'll give you those 2 minutes back. So we will start very close to the top of the hour, but a little smidgen after it. We'll see you in about an hour and 10 minutes. Okay. Hope this has been helpful to you. We know it's a long day. We're doing our very best to be very, very practical with the advice. Have a good break. We'll see you in an hour and 10 minutes.